All other matters, if there is urgency, you'll have to file an application for early hearing. It will come.
This is a land acquisition matter. I'm sorry.
I have said only fresh matters you can please give. If you want old matters to be listed, you'll have to file an application for early hearing. Otherwise,
A land acquisition matter. My lord.
yes, please call out.
My lord, one submission, my lord. My lord,
Don't have to make any submission. If
No,
it's
my
a
lord.
fresh matter, you please give.
6 matter connected, one is listed today, so another 5 matter to be taken at.
ಅದನ್ನ ಇವಾಗ ಇಂಗ್ಲಿಷ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ. Please wait when the matter reaches.
My lord,
Yes.
it's been coming in B group. So IA has been pending.
Yes.
Number 1 Adinanapa.
ಡಿಸ್ಮಿಸ್ ಫಾರ್ ಡಿಫಾಲ್ಟ್ ಆಗಿ ಅದು ಆರ್ಡರ್ ಆಗಿದೆ.
Yes. Yes.
ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು DC ಅವರು ಸ್ಟೇಜ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಸ್ಟೇ ಮಾಡಬೇಕು ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅದ್ರ ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅನಕ್ಷರ ಎ ಪೇಜ್ ನಂಬರ್ 13. ಮತ್ತೆ ಆದೇಶದಲ್ಲೂ ರಾಂಗ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ನಮ್ದು ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲ, ಮತ್ತೆ ಅದ ಎಲ್ಲ ರಾಂಗ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡಿ ಇದ್ ಮಾಡಿದ್ದಾರೆ.
Page 15 is the order.
Huh?
Page 15 is the order. Sufficient opportunity has been given 2 years. Notice was not served to the respondent. 5 and 8. Sufficient opportunity was given on 2/3/2023. Then again the matter was posted 21/8/23. Then 5/2/24. Then 15/1/25. And he was present. Not that the petition was not present. Then the paragraph 2 and in page 3 of the order.
Earlier appeal was filed by the respondents, is it? Before the assistant commissioner?
Yes, sir.
Questioning what?
The order of the assistant commissioner. The appeal is also filed by this petitioner only.
Allalla.
His petition.
Puttegowda. Srinivas.
Assistant commissioner is there. Yes, when they challenge that order, they take that order in an appeal before the deputy commissioner.
Mutation order bearing the MR number 33 of 1993-94, 96-97, 2009-2010. ಏನ್ರಿ ನೀವು ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಮೆಜಾರಿಟಿ ಆಫ್ ದಿ ಟೈಮ್ಸ್ ಸಿಟ್ಟಿಂಗ್ ಇರಲ್ಲ ಸ್ವಾಮಿ. ACDC ಗಳು ಮೆಜಾರಿಟಿ ಆಫ್ ದಿ ಟೈಮ್ಸ್ there is no sitting. Even on the day I have filed it is paper publication ಗೆ ಹಾಕಿದೀವಿ, ಅದನ್ನ ವಜಾ ಮಾಡಿ ಇದು ಮಾಡಿ.
The assistant commissioner has passed the order in the year 2016.
Yes.
ಹೌದು. ಸ್ಟೇ ಇತ್ತಾ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ?
ಹೌದು ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ? where is that order?
ಆರ್ಡರ್ ಶೀಟ್ stay ಆಯ್ತು.
ದಿನಾಂಕ 19/2/2018 ತಡೆಯಾಜ್ಞೆಯನ್ನು ನೀಡಿದೆ. ಪೇಜ್ ನಂಬರ್ 39. ಉಭಯತ್ರಯರಿಗೂ ತಿಳಿಸುವುದು ಅಷ್ಟೇ.
21/8/23 the order was recalled. Extend the interim order. Interim order on 21/8/23. When he was not taking steps, even that the order was dissolved. Interim order was dissolved.
No. Even otherwise, that order was not extended.
It's not extended. ಅದರಲ್ಲೇ ಬರುತ್ತೆ 21/8/2001 ನ್ಯಾಯಾಲಯದ ಆದೇಶಗಳನ್ನು ಪಾಲಿಸಲು ಕಾರಣವಾಗಿದೆ. ಈ ಮಧ್ಯೆ ನೀಡಿರುವ ಮಧ್ಯಂತರ ಆದೇಶ ತೆರವುಗೊಳಿಸಿ ಪ್ರತಿವಾದಿಗಳ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದೆ. ಮತ್ತೊಂದು ಸೂಚನೆ ನೀಡಲಾಗಿದೆ.
Learned AG takes notice for response number 1 to 3. Issue notice to response number 4 to 10.
However, this is an order against dismissal. Because the revenue court follows the procedure of the civil court. You can file an application under order 9 there for recalling that order. ಅಲ್ಲ, this is a dismissal, not possible.
ಮಾಡಬಹುದಾಗಿತ್ತು.
ಅವ್ರು ಇಲ್ಲಿ ಬಂದ್ರು.
Anyway, they have filed a petition. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Yes.
Seal number 2, Virupaksha PH.
For petition. Which petitioner has sought for a writ of mandamus, my lord, seeking a direction to the fourth respondent, Tahsildar, my lord, to consider his representation, my lord, for rectification of the Sagoldi cheat, my lord, which was issued in favor of the father of the petitioner.
Rectification?
Rectification of Sagoldi cheat, my lord.
Yen rectification?
My lord, what had happened, my lord, the father of the petitioner, my lord, was granted, my lord, an extent of 1 acre.
Where is your representation?
Lord's annexure M is the representation, my lord, at page 43, my lord. Lord's annexure A, my lord, annexure B, if your lordship kindly peruse, my lord, is the grant, my lord, which was made in favor of the father of the petitioner, my lord. At page 19, annexure A, my lord, bottom of the page, my lord.
Annexure B?
I'm sorry, my lord, annexure A, my lord, at page 19. Bottom of the page, my lord. NC Huchvirappa, my lord, the father of the petitioner, serial number 2, my lord. He was granted, my lord, land, my lord, bearing survey number 50, measuring to an extent of 1 acre 37 guntas. My lord, in pursuance of the order of grant, my lord, if your lordship kindly peruse annexure D, my lord, page 26, my lord. Sagoldi cheat, my lord, at page 28, my lord. Sagoldi cheat, my lord, is issued in the name of the father of the petitioner to an extent of 1 acre 37 guntas. Subsequently, my lord, the father of the petitioner dies, my lord. Annexure G, page 33, my lord. The Tahsildar, my lord, issues a modified, my lord, official memorandum on 16th of April 2016, my lord, annexure G, page 33, my lord. Reducing, my lord, page 34, if your lordship kindly peruse, my lord, the next page. Serial number 2, Huchvirappa. Reducing the extent, my lord, from 1 acre 37 guntas to 19 guntas. My lord, this order was challenged, my lords, by the petitioner before the assistant commissioner, my lord. The assistant commissioner, my lord, at page 38, my lord, annexure K, my lord, allowed the appeal, my lord, which was filed by the petitioner, my lord, holding that the petitioner is in extent of the entire extent of 1 acre 37 guntas, and as such, the entry made, my lords, in respect of 19 guntas is illegal. At page 39, my lord, and directed the Tahsildar, my lord, to take steps for rectification of the Sagoldi.
You maintain an appeal under section 136 in this matter.
My lord, annexure K, my lord, page 38. The assistant commissioner, my lord,
Be challenged under 136 too.
my lord, the order, my lords, under challenge, my lords, was passed order of the Tahsildar.
136 is not meant for this.
My lords, since there was the
ಏನಾಯ್ತು?
assistant commissioner, my lord, at page 39, my lord, if your lordship kindly peruse, my lord. My lord, ಈ ಮನವಿ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಜರುಗಿಸಲು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಸೂಚಿಸುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ಹಾಲಿ 1 ಎಕರೆ 37 ಗುಂಟೆಯಲ್ಲಿ ಸ್ವಾಧೀನ ಹೊಂದಿರುವುದಾಗಿ ಮೋಜಣಿದಾರರು ವರದಿ ಮಾಡಿರುತ್ತಾರೆ. ಹಾಲಿ ಅನುಭವದಂತೆ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಈ ಪ್ರಾಧಿಕಾರದ ಆದೇಶ ಕೋರಿದ್ದು, ಸದರಿ ಪ್ರಕರಣವನ್ನು ತಹಸೀಲ್ದಾರ್ ರವರಿಗೆ ಹಿಂದಿರುಗಿಸಿದ್ದು ಸ್ಥಳ ಪರಿಶೀಲನೆ, ಮೂಲ ಮಂಜೂರಿ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಗೂ ದಾಖಲಾತಿಗಳ ನೈಜತೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ನಿಮ್ಮ ಹಂತದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. My lord, pursuant to the order of the assistant commissioner, my lord, we have made a representation before the Tahsildar.
2020 that order was made.
Please, my lord. Subsequently, my lord,
You are seeking Baradilla. You will have to challenge it in a manner known to law, not under 136(2). We will give you liberty, you go challenge it in the manner known to law. ಏನು ಮುಂದೆ ಹಿಂದೆ ಯಾವುದೋ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್
my lord, similar rit petition was filed, my lord, before this honorable court, my lord, seeking, my lord, this honorable court had allowed, my lord, the rit petition directing the Tahsildar to consider the representation.
ಮತ್ತೆ ಇನ್ನೊಂದ್ಸರಿ ಯಾಕೆ ಹಾಕಿದೀರಾ?
My lord, subsequently, my lord, we filed a representation.
ಸರಿ ಫೈಲ್ ಮಾಡ್ತೀರಿ ನೀವು?
ಅಲ್ಲ,
how many times you want to file the same type of writ petition with same similar prayers?
My lord, it is not a similar prayer, my lord. Previously, my lord, since the order, my lord, was not brought to the notice of this honorable court, the order passed by the assistant commissioner.
It's non-consideration of representation dated 19/8/2021. Rectification, same thing.
Now, my lords, an order is passed by the Assistant Commissioner, my lord, directing the Tahsildar to take steps, my
Open
lord.
to the,
My lord, now in the, if your lordship kindly peruse the prayer, my lord, sought for in the instant writ petition, my lord.
huh,
My lord, in view of the order which is passed by the Assistant Commissioner, my lord,
ಬರೋದಿಲ್ಲ.
directing the Tahsildar to take steps, my lord,
Which is that provision?
49.
Huh?
49.
49. Purple. Learned AGA takes notice for all the respondents. Next para. The prayer in this writ petition is to issue a writ of mandamus directing the fourth respondent, Tahsildar, to consider the representation dated 2012-2023 at annexure M given by the petitioner. Full stop. On going through the representation, this court finds that the petitioner is contending that his father, late Shri N.C. Huchaviraya, was granted 1 acre 37 guntas of land in survey number 50 of Tonachikoppe village, Kasba Hobli, Nelamangala Taluk, by way of an official memorandum dated 8/5/1997. Stop. Sagavali chit was also issued in favor of Shri Huchaviraya on 8/8/1997. Stop. However, after the death of the petitioner's father, the fourth respondent issued a modified official memorandum on 16/4/2016, reducing the extent of land to 19 guntas, on the ground that the petitioner's father was in occupation of only 19 guntas of land, and therefore he was entitled for grant of only 19 guntas of land. Full stop. Next para. The petitioner here filed an appeal under section 136(2) of the Karnataka Land Revenue Act of 1964, and the Assistant Commissioner passed an order on 25/11/2020, directing the Tahsildar to verify physically the extent of land in occupation of the petitioner, peruse the land records, and thereafter take a decision in accordance with law. Stop. When no decision was taken by the Tahsildar, the petitioner herein filed writ petition number 20075 of 2021. With a similar prayer seeking direction to the Tahsildar to consider the representation dated 19/8/2021. Full stop. This court, by order dated 19th of October 2022, disposed of the writ petition directing the Tahsildar to consider the representation within 8 weeks. Full stop. learned counsel submits that despite such directions at the hands of this court, no orders have been passed by the Tahsildar. And therefore, the petitioner gave one more representation dated 2023 at annexure M. Full stop. Next para. Learned AGA raises an objection that if the extent of land is reduced by the competent authority, that is the Tahsildar, the same could not be questioned by the petitioner under section 136 bracket 2 of the Act. Full stop. On the other hand, section 49 is the appropriate provision under which the petitioner should have challenged the order passed by the Tahsildar. Full stop. Next paragraph. The learned AGA is right in his submission that such an order passed by the Tahsildar reducing the extent of land could not be questioned under section 136 of the Act. Full stop. Subsection 2 of section 136 provides for an appeal remedy to a person affected by an order made under subsection 4 of section 136 4 or an entry certified under subsection 6 of section 129 within a period of 60 days from the date of communication of the order or the knowledge of the entry certified. Full stop. Section 129 of the Act pertains to registration of mutations and entry of disputed cases in respect of the mutation entries and not in respect of an order passed by the Tahsildar reducing the extent of land having regard to the rules governing grant of land. Full stop. Next paragraph. Consequently, the writ petition stands disposed of, reserving liberty to the petitioner to raise a challenge under section 49 of the Act if the petitioner is aggrieved by the action of the Tahsildar in reducing the extent of land ordered according.
Right.
49A and specific.
Huh?
49A is specific. A.
49?
Any order passed by the subordinate of the assistant commissioner, any revenue officer, is before the assistant commissioner. You approach the assistant commissioner under a wrong provision. 49A is.
That's correct.
Correct.
ಅಲ್ಲಿ whoever has passed an order ಯಾರ ಮುಂದೆ ಅಪೀಲ್ ಹೋಗುತ್ತೆ ಅಂತ ಸ್ಪೆಸಿಫೈ ಮಾಡಿದ್ದಾರೆ.
Number 3, Srinivasan MY, 79AB.
Proceedings 79, right?
Huh?
79A and B proceedings, my lord.
Huh.
In view of the my lord, ordinance of the state government, the assistant commissioner will not follow the my lord, the contentions of the my lord, the petitioner. Notice was served and I have submitted arguments also.
2019.
To 20, my lord. The order is 2020.
Huh?
2020, order is 2020. The case is 2019. 16 and 17.
17/3/2020.
Please, my lord.
Proceedings were initiated in the year 2016-17.
16,
itself.
17.
ಏನಿದು ಈ ಕುರಿತು ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 28/2/2017 ರಿಂದ 23/5/2017 ವರೆಗೆ ನಡೆಸಿ ಸರ್ಕಾರಕ್ಕೆ ನಿಹಿತಗೊಳಿಸಲು ಉಲ್ಲೇಖ 2ರ ರೀತಿ ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ.
Yes, against that, my lord, dismissed the, my lord, the petition. Against that, my lord, we have filed appeal before the KAT. KAT has, my lord, remanded the matter, my lord, on 29/4/2019. But again, my lord, the assistant commissioner dismissed, my lord, the violation of 17 PNP.
Where is the order of the KAT?
So, I don't have copies of, my lord, KAT.
Why?
So in page 20, my lord, even learned, my lord, assistant commissioner, my lord, has mentioned the KAT, my lord, case number, the ಉಲ್ಲೇಖ 1 ಕರ್ನಾಟಕ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಧಿಕರಣ ಅಪೀಲು ಸಂಖ್ಯೆ 118617 ದಿನಾಂಕ 29/4/2019. He has reminded the matter to assistant commissioner to reconsider the.
When did the amendment come into force?
Amended, my lord, 13/7/2020. 13/7/2020.
It was enacted on 30/12, madam. 30/12/2020.
30/12.
12. Announced in Gazette.
30/12.
ಹೌದು 2020.
ಕೊಡ್ರಿ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್. On 17/3/2000, when was this order passed?
Order passed, my lord, 17/3/2020.
20.
Yes.
Then you didn't go before the KAT.
No, my lord.
Why?
Now, my lord, after amendment, my lord, the KAT, my lord, had not entertained.
That's why we asked when was the when did the amendment come into force?
Amendment, my lord, even, my lord,
30/12/2020.
the ordinance, my lord, come into force, my lord, with effect from 13/7/2020.
Where do you get that?
My lord, I have mentioned in my ground, my lord, para 17, para 7, my lord, para 7, page 5 of the petition.
Deemed to have come into force with effect from 1/3/1974.
74, my lord.
ಅದು retrospective operation.
Retrospective action. the state by of Karnataka land reforms, my lord, omitted section 79A, B, C from the principal act with effect from 1/3/1974.
Adaito, but when was it, notified?
Notified notice. Yogana, notified.
Land Reforms Act 312 million.
13/7/2020.
20.
Please, ma'am.
ಅದಾದ್ರೂ it is after the order.
After the order.
ಮತ್ತೆ?
But my lord, 1374 is the retrospective effect.
ಅದಿರ್ಬೋದ್ರಿ, the ordinance itself came on 13/7.
13/7/2020.
This order was
Order is
passed in the
before
month
that.
of March.
Before
What
that.
were you doing? Why did you not approach the KAT?
Once again, my lord, KAT, my lord, after to 13/7/20, my lord, KAT, my lord, did not entertain the petition.
That will come to your rescue only if you have filed the appeal.
Yes, filed the
You
appeal.
not filed the appeal.
Not filed the
Then, as on the date, please see the saving clause now. Please see section 13 of the Amendment Act. ನೀವೆಲ್ಲ ಇದೆಲ್ಲ ಏನು ನೋಡೋದಿಲ್ಲ. Simply file some papers, ಕೋರ್ಟ್ ಎಲ್ಲ ಮಾಡ್ಕೋತಾರೆ ಬಿಡ್ರಿ ಅಂತ. Please see the saving clause, section 13. Notwithstanding the omission of section 79A, B and C with effect from 1st of March 1974, cases already disposed of before the publication of the ordinance shall not in any way be affected. Then it's an order passed before the ordinance. It will not be affected. All cases pending on the date of publication of this act pertaining to section so and so and consequential thereof shall stand abated pending consideration. If you had filed the appeal, then it would be pending consideration. You did not file appeal.
Party recently came to know.
ನಾವು ಹಂಗೆ ಹೇಳಿದ್ರೆ ನೀವು ಪಾರ್ಟಿ ಮೇಲೆ ಹೇಳಿದ್ರೆ ಅರ್ಥ ಇಲ್ಲ.
True, my lord, but
ಕೊಡ್ರಿ, ಅದು ನಾವು ಆರ್ಡರ್ ಮಾಡಿರೋದು. ಅದು matters remanded back to the assistant commissioner.
the lordship was passed the order and directing the assistant commissioner to reconsider the case of the petition, including the consequences of subsequent amendment. Lordship was remanded the matter in one case, my lord.
Lordship.
ಇದೇ ಆರ್ಡರ್. ಬರ್ಕೊಳ್ಳಿ. Learned AG takes notice for all the respondents. the petitioner is aggrieved of the impugned order dated 17/3/2020 passed by the Assistant Commissioner, Mandya subdivision in proceedings bearing number LRF 307/1617, which was initiated by the Tahsildar invoking sections 79A and 79B of the Karnataka Land Reforms Act. Full stop. As seen from the impugned order, earlier, the appeal was allowed by order dated 23/5/2017, directing a restoration of the lands in favor of the government. Full stop. The petitioner approached the Karnataka Appellate Tribunal in appeal number 1186 of 2017, and the tribunal allowed the appeal on 29/4/2019 while remanding the matter back to the Assistant Commissioner for fresh consideration. Full stop. On remand, the Assistant Commissioner has considered the matter once again and has passed the impugned order holding that the petitioner has violated the provisions of section 79A and 79B while purchasing the agricultural lands under registered sale deed dated 23/9/2016. Full stop. Next para. However, learned counsel for the petitioner submits that this court has consistently held paragraph number 3 in the same order. ಇದು petition number 9605 of 2024 dated 1st of April 2024, same order.
Number 4, Virupakshaya PH.
It's the father of the petitioner herein, my lord, had filed an application, my lords, in forum number 53, my lord. The land grant committee, my lord, had passed a resolution, my lord, at annexure B, my lord, page 21, my lord. On 4/1/2004, my lord, granting an extent of 1 acre 11 guntas, my lord, in survey number 5, my lord, in favor of the father of the petitioner. However, my lord, in terms of the order of grant, my lord, Sagoli cheat, my lord, was not issued, my lord, but with Tahsildar, my lord, in favor of the father. As such, my lord, representations, my lord, were addressed by the petitioner, my lord, to the Tahsildar, my lord, to issue Sagoli cheat and also, my lord, effect Khata, my lord, in the name of the petitioner, my lord, in respect of the granted land. Those representations, my lords, have been pending, my lords, consideration before the Tahsildar, my lord. As such, a writ of mandamus, my lord, is sought to the fourth respondent, Tahsildar, my lord, to consider the application of the petition. The representation, my lord, is at annexure E, my lord, page 42.
I'll take instructions because the said committee has passed in 2004 Subsequently, 2007 Panchayati Parikate has been drawn. 2014 ಅಲ್ಲಿ ಅವ್ರ ತಂದೆ ತೀರೋಗ್ತಾರೆ. Till then they don't make any representation. They only make it in 2023. So ಅಲ್ಲಿ status I'll take the
ಪಾರಿಕತ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
2007 ಅಲ್ಲಿ ಅವ್ರ ತಂದೆ ಇದ್ದಾಗೇನೆ ಪಾರಿಕತ್ ಆಗತ್ತೆ. 2014 ಅಲ್ಲಿ ಅವ್ರ ತಂದೆ ತೀರೋಗ್ತಾರೆ.
Correct. ಅಂದ್ರೆ if they have partitioned the property,
Please.
it means they are of the opinion that land has been granted to me,
ಹೌದು.
and therefore I am entitled to partition the property.
ಸಾಗುವಳಿ ಚೀಟಿ has also not been issued. ಇನ್ನು ಅವ್ರ ತಂದೆಗೆ ಸಾಗುವಳಿ ಚೀಟಿನೂ ಕೊಟ್ಟಿಲ್ಲ.
So therefore you will have to verify from your records,
Please.
if it is true that such an order was passed, you should have proceeded to issue the sagvali sheet.
Please.
Verify madli. If it is true, then let him proceed in accordance with law.
Please.
Learned HCGP takes notice for all the respondents. Next para. The grievance of the petitioner is that despite a representation being given by the petitioner on 4/11/2023 to the third respondent Tahsildar, Nagmangala Taluk for issuance of Sagvali chit pursuant to the decision of the Committee for Regularization of Unauthorized Occupation taken on 4/1/2004, regularizing the unauthorized occupation of the petitioner's father in respect of
Survey number 5,
1 acre
11
One
guntas.
guntas.
1 acre 11 guntas.
11 guntas in survey number 5 of
Govindagatta village.
Govindagatta village, Belloor Hobli, Nagmangala Taluk. The Tahsildar has not taken any action. Full stop. Next para. Learned HCGP submits on the basis of the material available on record, furnished by the petitioner along with the writ petition, that if it is true that the committee had taken such a decision in the year 2004, and the fact that the petitioner's father, during his lifetime sought to partition the property, including the land in question, under Panchayat
Pal
Parikat dated
27 December 2007.
27th of December 2007 at Annexure D, then it is seen that the petitioner's father during his lifetime did not seek issuance of Sagvali chit. Full stop. Admittedly, no revenue entries have been mutated in the name of the petitioner's father. And after a belated period of nearly 20 years, this representation is given by the petitioner. Full stop. Next para. Having heard the learned counsel for petitioner, the learned HCGP, and on perusing the petition papers, this court is of the considered opinion that at any rate, the third respondent Tahsildar Nagmangala Taluk is duty bound to consider the representation given by the petitioner. Full stop. It is the duty of the petitioner to verify from the records as to whether such a decision was taken by the Committee for Regularization of Unauthorized Occupation. Full stop. If it is found that such a decision was indeed taken by the committee, comma, then the Tahsildar is required to proceed in accordance with law for issuance of Sagwali chit. Full stop. Next para. In that view of the matter, the writ petition stands disposed of with a specific direction to the third respondent, Tahsildar, Nagmangala Taluk, to consider the representation dated 4/11/2023 at Annexure E given by the petitioner, comma, verify the records as stated herein above and proceed to pass necessary orders on the representation given by the petitioner, comma, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order, ordered accordingly.
Serial number 5. Serial MP, Yudappa.
Issued by the
Learned HCDP is permitted to file memo of appearance within a period of 4 weeks of previous matter longer.
The petitioner applied the revenue records in respect of to conduct the Podi Durasti. The Tahsildar issued an endorsement stating that as per the charge ಪಟ್ಟಿಯಲ್ಲಿ ದಾಖಲೆ ಅಭಿಲೇಖಾಲಯದ ಚಾರ್ಜ್ ಪಟ್ಟಿಯಂತೆ ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. I was granted the land, 2 acres of land in the year of 90.
Where is it?
At Annexure A, page number 13. Sir.
Annexure A is your representation.
My representation, next page, endorsement, Annexure B. ಹೊಸಕೋಟೆ ತಾಲೂಕು ಜಡ್ಗೇನಹಳ್ಳಿ ಹೋಬಳಿ ಅರಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರು ದಾಖಲೆಗಳನ್ನು ದೃಢೀಕರಿಸಿ ನೀಡಲು ಕೋರಿರುವ ಬಗ್ಗೆ ನಿಮ್ಮ ಮನವಿ ದಿನಾಂಕ 26.
What is your request?
My request is
ಜಮೀನಿನಲ್ಲಿ ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರಿ ದಾಖಲೆಗಳನ್ನು ದೃಢೀಕರಿಸಿ ನೀಡಲು
certified copy of ಸಾಗುವಳಿ ಚೀಟಿ OM ಕಿಮ್ಮತ್ತು ಚಲನ್ ಸಾಗುವಳಿ ಚೀಟಿ ವಿತರಣೆ ವಾಹಿ ರೆವಿನ್ಯೂ ಸ್ಕೆಚ್ ಕಾಪಿಗಳು ನಕಲು ದೃಢೀಕರಣ ನೀಡಲು ಕೋರಿ. To these documents are required to conduct the Podi proceedings. Podi Durasti. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೊಸಕೋಟೆ ತಾಲೂಕು ಜಡ್ಗೇನಹಳ್ಳಿ ಹೋಬಳಿ ಅರಳೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 9ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ನನ್ನ ಹೆಸರಿಗೆ LND DSR 5/1/81 ಮಂಜೂರಾಗಿದ್ದು ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಇದರಂತೆ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಪಹಣಿ ಮತ್ತು ಮುಟೇಶನ್ ಸಹ ಇರುತ್ತದೆ. ಈಗ ಜಮೀನು ಪೋಡಿ ದುರಸ್ತಿ ಮಾಡಿಸಲು ಮೂಲ ದಾಖಲೆಗಳ ದೃಢೀಕರಣ ನಕಲು ನೀಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ. This is the representation made by me. In respect of this, the endorsement issued. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮುನಿಯಪ್ಪ ಬಿನ್ ಹನುಮಪ್ಪ ಅರಳೂರು ಜಡ್ಗೇನಹಳ್ಳಿ ಹೋಬಳಿ ಹೊಸಕೋಟೆ ತಾಲೂಕಾದ ನೀವು ಹೊಸಕೋಟೆ ಜಡ್ಗೇನಹಳ್ಳಿ ಅರಳೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 9ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ದಿನಾಂಕ 81ರಂದು ಮುನಿಯಪ್ಪ ಬಿನ್ ಲೇಟ್ ಹನುಮಪ್ಪರವರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರು ದಾಖಲೆಗಳನ್ನು ದೃಢೀಕರಿಸಿ ನೀಡಲು ಉಲ್ಲೇಖ ಪತ್ರದಂತೆ ಕೋರಿರುತ್ತೀರಿ. ಪ್ರಾಸ್ತಾವಿತ ವಿಚಾರವಾಗಿ ಅಭಿಲೇಖಾಲಯದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಹೊಸಕೋಟೆ ತಾಲೂಕು ಜಡ್ಗೇನಹಳ್ಳಿ ಹೋಬಳಿ ಅರಳೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 9ರಲ್ಲಿ 2 ಎಕರೆ ಜಮೀನು ರಂತೆ ಮುನಿಯಪ್ಪ ಹನುಮಪ್ಪರವರಿಗೆ ಮಂಜೂರಾಗಿರುವ ಮಂಜೂರಿ ಕಡತವು ಅಭಿಲೇಖಾಲಯದ ಚಾರ್ಜ್ ಪಟ್ಟಿಯಂತೆ ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಎಂದು ತಿಳಿಸುತ್ತಾ ನೀವು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯನ್ನು ಮುಕ್ತಾಯಗೊಳಿಸಿದೆ. I have produced all the document to show that I was owner of the property by virtue of grant. Subsequent.
What did you do after the grant?
The revenue records had been changed into my name. RTC mutation as per the Sagwali chit. Sagwali chit is Annexure C. The mutation is at Annexure D. And RTC is Annexure E. Typed copy ಹಾಕಿದ್ರು ಬ್ಲರ್ ಆಗಿರೋದ್ರಿಂದ. Along with me, there are 10 members had been granted, which is produced at Annexure.
Worker. Learned AGA takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. The grievance of the petitioner is that when the petitioner sought for issuance of certified copies of the grant order,
OM किंमत चलन सागवडी चिठ्ठी वितरणावही revenue sketch.
सागवडी वितरणावही revenue sketch.
certified copy of the issue register, comma, for the purpose of enabling the petitioner to seek OD and Durasti of the granted lands, comma, the Tahsildar has issued the impugned endorsement at Annexure B stating that on verification in the office, such records are not available. Full stop. Learned counsel has pointed out to Annexure C, comma, Sagwali chit, and Annexure D,
Grant.
the
The grant registers.
huh?
Grant register. Those who are all granted the lands in the same survey number. At
list
page
of
22.
list of grantees in respect of the same survey number, where the name of the petitioner is found at serial number 618.
Yes.
18 or 15 array?
15.
15. 615. Full stop. Next para. Learned AGA is directed to secure instructions from the second respondent Tahsildar Hoskote Taluk. Full stop. Release this matter on 5th of August.
5, 6, 7 and 10 are the same connected matters.
Also be connected together.
6, 7, huh?
5, 6, 7 and 10.
Sorry, same orders.
Lordship, can you connect the same, because all of the grantees are the same.
Same survey number.
Same, sir.
Serial number 6, 7 and 10
Also.
are connected with number 5. Yes.
Serial number 8, PD Surana.
For the respondent evidence.
Then notice issue ಆಗಿದೆಯಾ?
But filed caveat manod. Notice is not yet issued.
The 10.5 guntas of land, partition suit is pending. The respondents filed an application and the application was filed by the respondent 1 and 2. Sorry. Respondent 8 and 9. One ನಿಮಿಷ.
ಚಂದ್ರಮ್ಮ ಮತ್ತೆ ಕಮಲಮ್ಮ.
Chandramma is the daughter of Chinnappa. ಎಲ್ಲ ಅದು
So serial number 10,
Respondent number 8 and 9 filed an application.
AC Kamalamma,
Respondent number 8 and 9,
8 and 9 alla.
they filed,
Chandramma and AC Kamalamma filed the appeal.
yes. Appeal, in the appeal, before
Where
that,
is Chandramma?
before that, there is an order made by Tahsildar.
Huh?
Petitioner.
Before that,
Chandramma is the petitioner.
petitioner.
The appeal itself is filed by both of them together.
Yes, thereafter she is dead,
Chandramma and Kamalamma filed the appeal before the Assistant Commissioner.
Commissioner. In that proceedings, this respondent 8 and 9 got impleted. They say there is a will left by this, the respondent, one of the respondent, that is this, Veeranna's wife. Kindly see the suit pending before the trial court.
Hmm.
She is the second defendant in the suit.
Hmm.
The property was not belonging to her husband. It was the property of her, Veeranna's father. So Chandramma, being a daughter, also succeeded.
Khata is now standing in whose name?
The Khata was standing in the name of AC Nagaraj and Veeranna. Veeranna expired. Vasant Kumari has also expired. They have no issues. Therefore, the property goes to the second class heirs. So this, on the death of the
All this has to be decided by civil court.
civil court. Now, what has happened is, he filed an application before the Tahsildar, this respondent 8 and 9, stating that the Khata may be made in my favor. Kindly look to annexure D at page 50.
The names of response number 7 and 8 jointly in the revenue records in respect of survey number 78 measuring
10.5 kuntas.
In terms of the bill dated 23/2/2021.
Now, he filed an application, kindly.
And the same shall be subject to the outcome of the pending suit in OS number so and so.
The Khata has to be retained in the name of the original owner. They can't be done. Kindly see annexure D at page 50. The application filed by this respondent 8 and 9 was rejected. They did not challenge the order.
By the Tahsildar.
By the Tahsildar. They did not challenge the order.
ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಪ್ರಕರಣ ಬಾಕಿ ಇರುವುದರಿಂದ ಹಾಲಿ ಪಹಣಿಯಲ್ಲಿನ ನಮೂದನ್ನು ಯಥಾಸ್ಥಿತಿ ಮುಂದುವರಿಸಲು ಆದೇಶಿಸಿದೆ.
This order was not challenged.
The Deputy Commissioner has dismissed your
revision petition without hearing me.
Yes.
Lords, on the basis of will.
How can you go and seek change of mutation entry when the suit is pending?
Lords, the land in question, my lords, was originally standing in the name of Vasant Kumari, my lords. After the death of her husband, my lords, Veeranna. Initially, my lords, it was standing in the name of Veeranna. After his death, my lord, Vasant Kumari's name, my lord, came to be entered in the revenue records. During her lifetime, my lord, she has executed a will, my lords, in favor of the respondent number 8 and 9. My lord. We filed an application before the Tahsildar, my lord, to mutate our names. The Tahsildar, my lords, annexed.
Who has filed the suit?
Suit, my lord, is filed by the
2021.
Who has filed the suit?
21.
Who has filed the suit?
the petitioner
Chandramma.
herself.
You are,
The petitioner
I have
has
filed
filed
the
the suit.
suit.
you have filed
Chandramma.
the suit.
Filed the suit.
You are also seeking a share in that
Share
property.
in property because the property was of my father. My father's property. Veeranna was not the absolute owner.
My lord, in
He
the
had
year-
only 1/7 share in the property.
My lord, in the year 1999, my lords, on 1/7/1999, there is a registered partition deed, my lords, executed between the family members, my lord, of Veeranna. The petitioner herein, my lords, is the sister of Veeranna. She claims, my lord, suppressing the fact, my lords, that there is a registered partition between the family members, my lord, prior to, my lords, amendment, my lords, of the Hindu Succession Act. This was in the year 1999, my lords, a partition deed was executed between the family members. 1/7/1999, my lord.
We are not parties to it.
1/7/1999, there is a partition
That
deed,
will
my
not
lord,
give the right.
between Veeranna and his other brothers. My lord, in terms of the partition deed, my lords, mutation was effected, my lord, as per.
All that will be
It is the subject matter of the suit, my lord.
then
My lord,
it has
the-
to be decided in the suit.
In the suit, the land in question, my lord, which was fallen to the share of Veeranna, my lord. After his death, my lord, the name of Vasant Kumari, my lord, continued. She, my lord, Vasant Kumari and Veeranna, my lord, did not have any issues, my lord. They bequeathed, my lords, the land in question in favor of the respondent number.
See, wherever there is a will, there is a dispute.
My lord, that is, we have, my
Therefore,
lords,
it has to
we have
be
also
decided by
included,
the civil court.
my lords, we have filed an application before the civil court, my lord, seeking to implead, my lord, as defendants.
Yes.
And that application is
You have
pending.
a right, you contest the matter,
Please,
please
ma'am.
contest the matter. But in the meanwhile, you could not have approached the authorities to change the revenue entries.
My lords, they had sought, my lord, to enter their names, my lords, in the revenue records. All that the assistant commissioner has,
Objected for it.
my lords, we objected. All that the assistant commissioner has done, my lord, in place of, my lords, a dead person, Vasant Kumari, my lord, as per the will, my lord, our names have been directed to be
He
entered.
is now a disputed
The subject, my lords,
document.
in fact, the assistant commissioner has observed, if your lordship kindly peruse, it would be subject to, my lords, to the outcome of the
That is
pending
what the Tahsildar also had said, but he has done the right thing by saying, please go get the matter decided. Until that, let the revenue entries remain the same.
The Tahsildar order is
But
not challenged by
Tahsildar,
them.
my lord, it-
They did not challenge the Tahsildar order.
That the Tahsildar was right when saying, please go get the dispute settled before the
My lord,
civil court.
Tahsildar also says, my lord, that the appeal is pending before the assistant commissioner. As such, my lord, the
appeal was
application,
filed.
if your lordship peruse, my lord, page 52.
Barkal. Learned AGA takes notice for response number 1256. Learned counsel, Shri PH Virupakshaya.
Lord, there are
has
other
entered
respondents
appearance
also, my lord.
for respond number 8. Full stop. Learned counsel submits that he would take notice for response number 7.
My lord, respond number 9, my lord.
For
8
respond
and
number
9.
9.
8 and 9.
8 and 9. What about the others?
Others, my lord, notice will have to.
Issue notice to response number 9 to 13. BDA ಏನಕ್ರಿ?
ಅಲ್ಲ BDA ನ ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡ್ಯಾರ ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಯಾರ ಹೇಳಿದ ಅದಕ್ಕೋಸ್ಕರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವಾಸ್ರಲ್ಲ ನಾವು ಮಾಡಿರಲಿಲ್ಲ.
Notice to respond number 14 is not necessary.
Yes. The interim order may be granted.
Next para. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures from the learned AG. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner has filed a suit in OS number 5065 of 2021 on the file of the learned
City Civil Court, Bangalore. CCH-12. Annexure B at page 33.
16th additional city civil judge at Bengaluru,
Bangalore.
seeking partition and separate possession of the
Or 1/7 share.
family properties, including
ಇದು ಒಂದೇ ಇರೋದು. It is the only property.
Ondena
ಅಷ್ಟೇ ಇವಾಗ ಇರೋದು ಒಂದೇ.
in respect of the property in question. Full stop. When the matter is pending consideration, ಅಲ್ಲ ನೀವೇ ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ರಿ?
ಅಪೀಲ್ ಹಾಕಿದ್ದು ಬಿಕಾಸ್ ದಿ ಎಂಟ್ರಿ ವಾಸ್ ಮೇಡ್ ಇನ್ ದಿ ನೇಮ್ ಆಫ್ ವಸಂತ ಕುಮಾರಿ. ವಸಂತ ಕುಮಾರಿಗೆ ಎಂಟ್ರಿ ಮಾಡಿದಾಗ ದಟ್ ಇಸ್ ಅಪೀಲ್ ದಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್. Instead of deciding whether the entry made in Vasant Kumari is correct or not, he impletes this respondent 8 and 9 in the appeal and passes the order.
The petitioner hearing along with her sister AC Kamlamma filed an appeal under section 136 bracket 2 of the Karnataka Land Revenue Act before the Assistant Commissioner, Special Assistant Commissioner.
Lord, sir, may I make one submission? Lord, Annexure F is the order of the Deputy Commissioner. Lord,
Without hearing me.
They contend, my lords, no notice was issued to the petitioner or the respondents. On the same day, my lord, the revision is dismissed.
ಅಲ್ಲ ಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ ತಕ್ಷಣ ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲೇ ಹಾಕಿದ್ದೇನೆ ಲಾರ್ಡ್ಶಿಪ್ either my lord
Because he is a DC.
direct the Deputy Commissioner, my lord, to consider the matter on merits.
There is nothing for them to consider now. You will have to await the results of the suit. That's all.
We filed the appeal against the entry made in favor of this Vasant Kumari.
Questioning the mutation entry.
I'll file my
Bearing MR
objection, my
number.
lords. Lordship may have this matter next week. I'll file my formal objections.
H6/2020-21 dated 7/11/2020, whereby the mutation entries which were earlier standing in the name of
Veeranna.
late Sri Veeranna were
Changed to Vasant
changed
Kumari.
in favor of
Vasant Kumari.
Srimati Vasant Kumari. Stop. During the pendency of the appeal, ಯಾರು ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ದು?
The respondent number 8 and 9. And they said we are the legatees under the will, the assistant commissioner passes the order.
Manoj Kumar and Nikhil.
Please,
Huh?
please.
Yes.
Respondents number 8 and 9 herein impleaded in those proceedings, and the assistant commissioner passed the impugned order on 6th of January 2025. Directing the mutation entry of the names, mutation entry of the names of response number 8 and 9 herein jointly, comma, on the basis of a registered will dated 23/2/2021 said to have been left behind by Shri Veeranna,
Vasant Kumari,
Vasant Kumari.
Srimati Vasant Kumari,
wife of Veer.
Wife of Iran.
wife of late Shri Veeranna. Full stop. Learned counsel for the petitioner submits that admittedly Shri Veeranna and Srimati Vasant Kumari had no issues, and the suit is now to be decided on the basis of the said admitted fact that
The property was owned by Chinnappa.
the previous owners, the previous owners, the previous khatedars,
Chinnappa. Original Khatedar Chinnappa.
the previous khatedars,
Veeranna and
Alla,
Shri Veeranna and Srimati Vasant Kumari had no issues, and moreover, the other members of the family are raising a claim that since the property in question is an ancestral property and joint family property, comma, they too have a share in the property. Full stop. Next para. Alle seskolli. Learned counsel submits that the revision petition filed before the deputy commissioner was rejected by the deputy commissioner on the same day when the matter was
An
taken up.
endorsement and the presentation form itself. Later the order is passed. 53. I'll quote all decisions more there. Because Nikhil Kumar's son is a retired deputy commissioner. 53 years old. Presented on same day, all decisions more there.
ಏನ್ ಹೇಳಿದಮ್ಮ? Was rejected on the same day when the revision petition was presented before the deputy commissioner.
And later the detailed order is made.
Thereafter, a reasoned order is passed on 15/4/2025. Full stop. Learned counsel submits that it's a well settled position of law that the revenue authorities will not be permitted to go into the question of title, and it is only the civil court which is entitled to decide the issue of title. Full stop. It is submitted that the Tahsildar had earlier rightly rejected the claim of respondents number 8 and 9 herein. Order
Order is at 50. Operative portion is 52 on 4/4/24.
at annexure D dated 4/4/2024, while directing the parties to get the matter settled, decided at the hands of the civil court in OS number 5065 of 2021. Stop. Next para. Learned counsel for respondents number 7 to 8 submits
8 and 9.
You have now taken notice for them also.
For 9, my lord, 7 I am not appearing.
7 ilva, only 8 and 9.
8 and
9
who are the legatees under the will.
submits that admittedly the khata was earlier standing in the name of Shri Veeranna. Huh?
Please. Veeranna, in terms of the partition deed, my lord, dated 1/7 in 1999.
And after his death, the Kata was mutated in the name of his wife, Srimati Vasanta Kumari. Full stop. The same was questioned by the petitioner herein, along with her sister, Srimati Kamalamma. And the impugned order has been passed by the Assistant Commissioner, permitting change of mutation entry in favor of response number 8 and 9 herein, on the basis of a will said to have been left behind by Srimati Vasanta Kumari. Full stop. Learned counsel would therefore submit that there is no infirmity in the order passed by the Assistant Commissioner. Stop. Next para. In the considered opinion of this court, the Tahsildar had earlier rightly rejected the claim of response number 8 and 9 herein. Full stop. It is well settled that disputed questions of title cannot be decided by revenue authorities. Full stop. Moreover, the petitioner herein has already filed a suit seeking partition and separate possession of the property in question, and therefore the Assistant Commissioner could not have permitted such change in the revenue entries when the suit is pending consideration before a competent civil court. Full stop. The dismissal of the revision petition at the hands of the Deputy Commissioner on the same day when the petition is filed, shows that the Deputy Commissioner seems to be biased against the petitioners. Full stop. At any rate, the impugned orders cannot be sustained. Full stop. Next para. Consequently, the writ petition is allowed. The impugned orders at annexures C and F passed by the third respondent, Special Assistant Commissioner, and the second respondent, Deputy Commissioner, are hereby quashed and set aside. Full stop. The revenue entry shall be restored as it was prior to the passing of the impugned orders. Full stop. Parties are directed to await the outcome of the suit in OS number so and so before seeking any change in the revenue entries. Full stop. Ordered accordingly.
That's all contentions regarding prior partition are also kept. Lordship may observe.
That is why I didn't even mention your prior partition. I have not even mentioned anything.
Serial number 9. Narasimha Reddy PR.
My lord, 4 and 6 respondent. My lord, OS case is pending 257/2025. Interim order also in favor of respondent 4 and 6.
Matter is called out. There is no representation for the petitioner. Release this matter on 5th of August.
Serial number 10 adjourned. Serial number 11. Srikanth NV.
Dated 7/4/2025 and 4/1/2024, my lord, annexure A and B. My lord, the petitioner has filed an appeal before the Assistant Commissioner challenging the MR interest, my lords, under section 136(2) of the Act, my lords. That was dismissed, my lord, as per annexure B. Subsequently, my lords, annexure A was filed, my lord, revision petition was filed, my lords, in RP number 148 of 2024. That is also dismissed, my lord, on the ground that there is a civil.
Learned HCGP
124.
takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioner is directed to serve copies of the petition along with annexures on the learned HCGP.
Yes.
So number 12, Nal Prasad Gurrappa.
I'm appearing for the petitioner. I am seeking a writ of certiorari, quashing the order of the fourth respondent by the annexure E, my lordship, which is cancelled the grant order, my lordship. It pertains to Hemavati Reserve project, my lordship. Already this honorable court in identical case set aside the cancellation order, my lordship, and remanded back to the SLO to have value of the standing trees, my lordship. I produced judgment of the, my lordship, at annexure F, my lordship.
ಯಾವ ground ಮೇಲೆ ರೀ?
The petitioner was not paid any standing value of the standing trees.
ಅಲ್ರಿ ನಿಮ್ಮ ಕೇಸಲ್ಲಿ ಏನ್ ಹೇಳ್ರಿ?
Annexure 4, my lordship, 4 and 8.
The relevant portion of the order.
Page number 32, my lordship.
32.
Last para, my lordship. ಅನುಬಂಧ 4 ಮತ್ತು 8ರ ಈ ಪ್ರಕರಣವು ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮದಲ್ಲಿ ದಾಖಲಾಗಿರುವ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಅರಣ್ಯ ಇಲಾಖೆಯಿಂದ ನಿರಾಕ್ಷೇಪಣಾ ಪತ್ರ ಪಡೆಯದೆ ಭೂ ಮಂಜೂರಾತಿ ಮಾಡಿರುವ ಕುರಿತು ವ್ಯತಿರಿಕ್ತ ಷರ ದಾಖಲಾಗಿರುವುದರಿಂದ ಈ ಕಚೇರಿಯಿಂದ ಪಡೆದಿರುವುದಾಗಿ ಹೇಳಲ್ಪಟ್ಟಿರುವ Annexure 4 is, my lordship, the value of the standing trees was not paid, my lordship, by the petitioner. ಮರಮಾಲ್ಕಿ ನಿಗದಿಯಾಗದೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವುದು.
Where do you get that?
At page number 29, my lordship.
29.
29. And one more, my lordship, ಅನುಬಂಧ 8. ಹೌದು, ಅನುಬಂಧ 4 ಮತ್ತು 8 ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
Both, they have not even got NOC, ಮರಮಾಲ್ಕಿನೂ ಕಟ್ಟಿಲ್ಲ ಹಾಗೂ ಫೇಕ್ ಡಿಸ್ಪ್ಲೇಸ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾವು ಮಾಡಿರೋ ಆರ್ಡರ್ ಅಲ್ಲಿ do you have the copy of the order that I have passed?
No, my lordship, I have with number, my lordship, with petition number.
ಹೇಮಾವತಿ ರಿಸರ್ವಾಯರ್ದು ನಂದು ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ತೆಗಿರಿ.
March 24.
We'll have this next week. Please get that.
I'll get the order.
Learned AGA. Takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the petition along with the annexures and the learned AGA. Next para. Release this matter on 5th of August
Kindly another
for
10 matters,
preliminary hearing.
10 matters are pending, my lordship, kindly connected.
Kodi number kodi.
Please.
Yes.
Still number 13, Virupaksha PH.
Matter is called out. There is no representation for the petitioner. Release this matter on 5th of August.
14, Subramania Kaushik RS.
And I appear for the petitioner. Orders under challenge are under 136(2) and 136(3). In a proceeding under 136(2) and 3, the Assistant Commissioner has practically re-examined a re-grant made under the Village Officers Abolition Act. But the petitioner's father purchased the Inam land as per the sale deed at Annexure A, my lord. Typed copy is available at page 23. Sheenappa's heirs are the petitioners before your lordship. Your lordship gets the name of Sheenappa in the 4th line.
The appeal was filed in the year 2022.
Appeal is filed in the year 2022, challenging an MR of 1999, my lord.
99.
There is no condonation of delay also.
Ah.
My lord, this pursuant to this sale deed, my lord, there is a re-grant order made at page 30. That is the order in 1999, the competent authority, which was the page 30, my lord.
Please come to the synopsis.
Please.
(23 to 1967).
1967 is the sale in favor of the petitioner's father, my lord.
Sheenappa.
Then this honorable court was approached for a mandamus to consider the re-grant application, pursuant to which 29/12/1999, the Tahsildar regularizes the sale and makes a re-grant. Khata is made out.
You know?
29/12/1999, if your lordship has the synopsis. On that day, my lord, the Tahsildar passes a re-grant order and regularizes the sale.
What is this order in writ petition number so and so?
Well, my lord, that was only a mandamus directing the Tahsildar to consider the application for re-grant. For re-grant of the land under the Village Officers Abolition Act. The order.
You filed the writ petition?
Yes, my lord. The present petitioner's father.
Where is that order?
My lord, your lordship gets the order at page 25.
25.
Sheenappa's heirs are the present petitioners, my lord. There. The page 27.
What was your prayer?
The prayer, your lordship gets it at page 25 itself. It was to consider the application for re-grant and regularize the sale. Because Sheenappa had purchased the property in 1967. In 1963, the Village Officers Abolition Act came into force. Therefore, in terms of section 5(4) of the Village Officers Abolition Act, the purchaser was, if the sale had to be regularized, I had to pay 15 times land revenue. Then the Tahsildar could regularize the sale in my favor. To grant that prayer, a writ petition for mandamus was filed. Accordingly, this honorable court allowed the writ petition and directed the Tahsildar to pass an order on the application. Paragraph 3. Pursuant to this, my lord, the Tahsildar considers the application and allows the application. That is Annexure C. Typed copy is at page 30. Operative portion at page 31. ಕೋಲಾರ ತಾಲೂಕು so and so ಹೋಬಳಿ so and so ಗ್ರಾಮದ ವಾಸಿಯಾದ ಕೆ ವಿ ಶೀನಪ್ಪ ಬಿನ್ ವೆಂಕಟರಾಮಯ್ಯ ಎಂಬುವರು ಒಕ್ಕಲೇರಿ ಹೋಬಳಿ ಚಿನ್ನಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 53ರಲ್ಲಿ 838 ತೋಟಿ ಇನಾಮತಿ ಜಮೀನನ್ನು ಇನಾಮತಿ ವಾರಸುದಾರರಿಂದ ಕ್ರಯಪತ್ರದ ಸಂಖ್ಯೆ so and so ರಲ್ಲಿ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವುದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 53ರಲ್ಲಿ 8 ಎಕರೆ 38 ಗುಂಟೆ ತೋಟಿ ಇನಾಮತಿ ಜಮೀನನ್ನು ಕ್ರಯದಾರರಾದ ಶೀನಪ್ಪ ಬಿನ್ ವೆಂಕಟರಾಮಯ್ಯ ಎಂಬುವರ ಹೆಸರಿಗೆ 15 ಪಟ್ಟು ಭೂಕಂದಾಯವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ಟಿಸಿಕೊಂಡು ಕ್ರಯವನ್ನು ಸ್ಥಿರೀಕರಿಸಿ ಖಾತೆ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. Pursuant to this, my lord, there is an MR entry at annexure D, typed copy at page 33. Now this order, my lord, is challenged at annexure K by in a proceeding under 136(2) before the assistant commissioner. This appeal is filed on 24/6/2022.
Miscellaneous appeal is filed at annexure E.
Well, the miscellaneous appeal which was filed under annexure E came to be dismissed by the learned district judge. That was not by these private respondents, my lord. It was by a different set of private respondents. The learned district judge holds that the appeal was not maintainable because what was under challenge was only an MR entry for which the relevant, for which the appropriate remedy would be under 136(2). With that observation, it was dismissed, my lord. The discussion, your lordship gets it at page 36. Now, subsequent to this, my lord, since the appeal was dismissed as not maintainable, certain other set of appellants approached the assistant commissioner under 136(2), that is at annexure F. That matter came to be disposed of in 47. Now, what is under challenge is, my lord, annexure K. A fresh challenge under 136.
What is annexure F?
My lord, annexure F is also an order under 136(2) filed by the same appellants who had approached the learned district.
Under section 49.
It is 136(2) read with 49, my lord. Your lordship sees the prastavana, 136(2) read with 49.
49 is the relevant provision.
49 would have been the relevant provision, my lord. That appeal is also dismissed. That appeal is dismissed. Reserve page 44 is the operative portion. That appeal is dismissed because they did not produce any documents in support of their appeal. Then once again, my lord, another appeal is filed in annexure G. In that, the appellant says he is not interested to continue the appeal. That is the withdrawal memo at annexure G.
ಏನು ಮೇಲ್ಮನವಿಯನ್ನು ಮುಕ್ತಾಯ ಮಾಡಿದೆ, ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು ಪುನರುಜ್ಜೀವನಗೊಳಿಸಲು ಅವಕಾಶ ನೀಡಿದೆ.
ಹೌದು.
To revive
on production of documents. Accordingly, they revived, and the revival appeal is area number 36 of 2019-20 at annexure G. After reviving, my lord, that appellant withdraws the appeal, that is the withdrawal memo at annexure G. In terms of the withdrawal memo, that appeal is also disposed of at annexure H. Now, thereafter, my lord, that order is challenged by the present private respondents before the deputy commissioner at annexure J. The deputy commissioner dismisses it, saying you may approach the assistant commissioner. Page 52. Now, thereafter, my lord, third point, he reserves liberty. ಮೇಲ್ಮನವಿದಾರರು ತಾವು ಬಾಧಿತರಾದಲ್ಲಿ ಯಾವ ಆದೇಶದ ವಿರುದ್ಧ ಬಾಧಿತರಾಗಿರುತ್ತೆಂಬ ದಾಖಲೆಗಳೊಂದಿಗೆ ಸಹಾಯ ಕಮಿಷನರ್ ಅವರಲ್ಲಿ ಮೊದಲನೇ ಅಪೀಲು ಸಲ್ಲಿಸಲು ಸ್ವತಂತ್ರ. Thereafter, my lord, at annexure K, this appeal under 136(2) is filed. Your lordship, the date on which the appeal is presented at page 57, 24/6/2022. And there itself at paragraph 7, your lordship may also notice.
What is their contention?
Their contention is that they are the absolute owners, my lord. My respectful submission is that contention has no legs to stand on, because by operation of land of the Karnataka Villages Officers Abolition Act, the land resumed in favor of the state.
Now, how are they claiming ownership?
They claim ownership. They say they are the legal heirs of the original Totidar, of the Inamdar. Unless they file a re-grant application, they have no right, my lord, because by operation of law, once the Village Officers Abolition Act came into force, the land stood resumed in favor of the state. And if at all there are any warsudars, they must make out an application and seek a re-grant under section 5, 6 or 7 of the Karnataka Village Officers Abolition Act.
Against whom you made the claim after you went back before the competent authority? Who are the respondents there?
My lord, in my proceedings, the competent authorities were before the competent authority, my vendors were the respondents, page 30. My vendors consented to me being made the re-granting. Annexure C, page 30. Vadi Nanswami, the petitioners, KV Srinappa.
The question is whether
Please.
this claim, without making the inamdar as a party.
The inamdars are made parties, my lord. The respondents therein are the legal heirs of the inamdars. Ramaya, Muniappa and VS Muniappa. The four respondents therein, they are the warsudars of they are the legal heirs of the inamdar.
Then who are the persons now claiming to be the legal
They have not established their right. They have not stated anything in the appeal memo is precisely my case, man. Kindly see their appeal memo. Their appeal memo facts they narrated page 55.
All right, we'll come to the order passed by the Assistant Commissioner.
Please. One another aspect, my lord, is that the Assistant Commissioner has not condoned the delay at all. An application for delay is filed. 23 years after the MR order, the 136(2) appeal is
not the question of mutation entry. It's the question of the original order.
Well, at the original, my respectful submission is the original order could not have been gone into by the Assistant Commissioner because the competent authority to decide such an appeal is the district judge under section 3 of the Act, my lord. Therefore, the Assistant Commissioner had no jurisdiction.
Yes.
Sir, please see the appeal memorandum filed by them, page 55. What right they claim? The appellant submits that the appellants are married, my lord.
Of course, if it is under section 136(2),
this could not have been gone into. That is my submission, my lord, because the relevant provision is section 3(2) of the Act. An appeal remedy is given to the aggrieved person to approach the district judge.
Village officer.
Village officers abolition. Before that, my lord, may I invite your lordship's attention to the definition of deputy commissioner under the Act, section 2D. May I read?
One nimisha,
please.
So the application itself is required to be decided by the deputy commissioner.
My lord, that is where, my lord. Kindly see the definition of deputy commissioner. Deputy commissioner 2D, my lord. Deputy commissioner means an officer appointed by the state government in respect of any area to perform the functions and exercise of the powers of the deputy commissioner under this Act, and where no such officer is appointed, the deputy commissioner of the district. My lord, pursuant to this is the enabling provision, my lord. In 1979, the Karnataka government notified the Tahsildar to exercise powers as the deputy commissioner. In fact, this honorable court has referred to that notification. May I kindly pass on? My lord, this is the coordinate bench order, my lord, wherein it was considered order. In the light of the notification number so and so dated, the first line itself. In the light of the notification number so and so dated 29/8/1979 of the government of Karnataka, exercising jurisdiction conferred by clause D of subsection 1 of subsection 2 of the Karnataka Village Officers Abolition Act number so and so, and in superstition of the notification dated so and so, the government of Karnataka appointed Tahsildars of the Talukas to perform the functions and exercise the powers of the Deputy Commissioner under the said Act in respect of the areas within their jurisdiction. Hence, the order dated so and so passed by the Deputy Commissioner invoking sections 5.3 and 5.4 of the Karnataka Village Officers Abolition Act is one without jurisdiction. The powers of the Deputy Commissioner under the said provisions having been delegated to the Tahsildar under the said notification. Therefore, my lord, the appropriate remedy would have been to challenge the said order before the learned district judge.
You raised that objection?
My lord?
You raised that objection before the Assistant Commissioner?
My lord, that objection was not necessary to be taken because as a matter of fact, other grantees had approached the district judge and that appeal was dismissed. That is the dismissal which your lordship finds at Annexure E, page 34 it commences, and page 38 the appeal is dismissed. Therefore, the order passed by the Tahsildar was already challenged in an appeal before the district judge and the appeal was dismissed. Page 38. Therefore, once again the said order could not have been, because that operates as res judicata, the order had attained finality. Once again, the validity of the order passed by the Tahsildar could not have been gone into.
It was not by these persons. That was not questioned by these persons.
That was not questioned by these persons.
So therefore, did you raise the objection?
Well, that of course is not raised before the Assistant Commissioner. Specific contention is not taken, but what contention is raised is that these appellants do not have any right, because even according to their appeal memorandum, a re-grant application is pending. Until a re-grant application is actually allowed in favor of these appellants, they have no right, because the land has already resumed in favor of the state by operation of section 4 of the Karnataka Village Officers Abolition Act.
Your application is still pending consideration.
No, my lord. The private respondent's application is pending consideration according to them. That they have stated so at page 55. Before the Assistant Commissioner, when they filed the appeal, the lordship takes page 55. My lord, there the appellant submits that appellants are in possession and enjoyment of the appeal memorandum property. Survey number so and so is the absolute property of the appellant's great grandfather by name Toti Chowda. He was doing Toti Inamti service along with his wife Toti Muni. The same has been to him under the Toti Inamti on 28/3/1930 as per the index of lands issued by the Tahsildar. Since then, he was in possession and enjoyment of the property. After the death of Toti Chowda, the ancestors of the appellants filed application for re-grant of the said property. The same is pending. So even according to the appellants, the application is pending. Of course, they have not disclosed the particulars of the application. We are not aware whether such an application is even made. Even according to them, when the application is still pending, they have no right over the property. By virtue of the impugned orders, my lord, Khata is now made out in their name, because if your lordship sees the Village Officers Abolition Act, immediately upon the appointed date, the land stands resumed in favor of the state. 1/2/1963. Therefore, unless these appellants make out a case, my lord, they do not have any right. And secondly, my lord, at page 7, they say they have filed an application for condonation of delay. I have produced the entire order sheet before the Assistant Commissioner. No order is passed to condone the delay. The appeal is taken up on merits without condonation of delay of nearly 23 years. And this aspect was raised before the Deputy Commissioner as to non-condonation of delay. That is not considered. In fact, I have raised that ground before the Deputy Commissioner at page 91. Top of page 91. I have even raised that ground. The Deputy Commissioner does not consider it. The reasoning of the Deputy Commissioner commences at page 95.
Yes.
Ubhayatrara, unnumbered paragraph. ಉಭಯತ್ರರ ವಾದ ಕೆಳ ನ್ಯಾಯಾಲಯದ ಆದೇಶ ಹಾಗೂ ಕಡತಗಳಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕೋಲಾರ ತಾಲೂಕು ಒಕ್ಕಲೇರಿ ಹೋಬಳಿ ಚಿನ್ನಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 53 ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಒಂದು ಪ್ರಶ್ನಿತ ಸಹಾಯಕ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ರಲ್ಲಿ ಮಾಡಿರುವ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ಉಲ್ಲೇಖ ಹಕ್ಕು ಬದಲಾವಣೆ MR ನಲ್ಲಿ KV ಶೀನಪ್ಪ ರವರ ಕ್ರಯ ಮಾಡಿದವರಿಗೆ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಕಚೇರಿಗಳ ಇನಾಮ್ ರಿದ್ದಾಯಿತಿ ಕಾಯ್ದೆ 1961 ಕಲಂ 5 ಅಥವಾ 6 ಅಡಿ ಮಂಜೂರು ಮಾಡಿರುವ ಯಾವುದೇ ಉಲ್ಲೇಖ ಇರುವುದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ಫ್ಯಾಕ್ಚುಯಲಿ ಇನ್ಕರೆಕ್ಟ್ ಮೈ ಲಾರ್ಡ್. MR ಎಂಟ್ರಿ ರೆಫರ್ಸ್ ಟು ಇಟ್. ನೇರವಾಗಿ ಕ್ರಯದಾರರಿಗೆ ಸೈಯದ್ ಬಶೀರ್ ಅಹ್ಮದ್ ವಿರುದ್ಧ ರಾಜ್ಯ ಸರ್ಕಾರ ಪ್ರಕಟಿತ ತೀರ್ಪನ್ನು ಉಲ್ಲೇಖಿಸಿ ಖಾತೆ ಮಾಡಲು ಆದೇಶಿಸಿರುತ್ತಾರೆ. ಇದು ಸದರಿ ಪ್ರಕಟಿತ ತೀರ್ಪಿನ ವಿರುದ್ಧವಾಗಿರುತ್ತದೆ. ಕ್ರಯ ಮಾಡಿದವರಿಗೆ ಇನಾಮ್ ರದ್ದಾಯಿತಿ ಕಾಯ್ದೆಯಡಿ ಮೊದಲು ಮಂಜೂರಾಗಬೇಕಾಗಿರುವುದರಿಂದ ನಂತರವಷ್ಟೇ ಕ್ರಯ ಪಡೆದವರಿಗೆ ಕ್ರಯದ ಪತ್ರದ ಮೇರೆಗೆ ಹಕ್ಕು ವರ್ಗಾವಣೆ ಆಗುವುದು ಪ್ರಶ್ನಿತ ತಹಶೀಲ್ದಾರ್ ಅವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ರದ್ದುಪಡಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಮನವಿದಾರರು ತಹಶೀಲ್ದಾರ್ ಅವರು ಮಾಡಿರುವ ಆದೇಶವನ್ನು ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮತ್ತು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಎತ್ತಿ ಹಿಡಿದಿರುತ್ತಾರೆ. ಆದರೆ ಸಹಾಯಕ ಕಮಿಷನರ್ ಅವರು ಖಾತೆ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸುವುದರಿಂದ ಅನುಚಿತವಾಗಿ
takes notice for response number 1 to 4. Issue notice to response number 5 to 9. Learned counsel for the petitioners is directed to serve copies of the petition along with annexures and the learned AG. Full stop. Next para. Learned counsel for the petitioners submits that contrary to section 3 of the Karnataka Village Officers Abolition Act, 1961, which provides for an appeal remedy before the district judge of the district, within 90 days of such a decision of the deputy commissioner, bracket alli, delegated to the Tahsildar, close bracket, an appeal is filed by the private respondents herein before the assistant commissioner invoking section 136 and section 49 of the Karnataka Land Revenue Act, questioning the mutation entry ಅಷ್ಟೇನ ಕ್ವೆಶ್ಚನ್ ಮಾಡಿದವರು
ಅಷ್ಟೇ ಕ್ವೆಶ್ಚನ್ ಮಾಡಿ
ಓನ್ಲಿ ಮ್ಯೂಟೇಷನ್ ಎಂಟ್ರಿ then
they have examined the whole regrant itself. That's without jurisdiction. But the prayer is at page 57. They say MR number but they cite the regrant order. Page 57 is their prayer at the bottom.
Full stop. The assistant commissioner has passed the impugned order on 38/2024 at annexure N, while holding that the alienee between 1/2/1963 and 7/8/1978 has no right to seek regrant in his own name, and his right is only to claim the benefit of doctrine of feeding the grant by estoppel, considering the provisions under the Karnataka Village Officers Abolition Act of 1961, which is beyond the powers of the assistant commissioner. Full stop. The deputy commissioner has also dismissed the revision petition while upholding such an order passed by the assistant commissioner. Stop. Learned counsel submits that the private respondents herein could not have challenged the mutation entry without questioning the original grant order passed by the competent authority under the provisions of the Act 1961. Stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures.
Annexure N.
P and N. Please. Till the next date of hearing.
Okay. Already instead of private respondent, it could be said 5 to 8, my lord, because 9 is my sister, but she has not joined.
Respondents number
5 to 8.
All right.
I'm obliged.
Little order re-grant,
Huh?
little order re-grant.
Aదే, re-grant,
My lord, may I seek hand delivery? My lord?
you will get it,
Could be
I think you will
uploaded.
get it, yes.
Please.
So number 15, Chandrasekhar PV.
I'm appearing for the petitioners. Pursuant to the partition. 8 gunta,
Huh?
I have questioned the order of the deputy court annexure H, page 56, 58.
Hmm.
The pursuant to the partition deed, my lord, the land in question fall into my share. The assistant commissioner has allowed my petition appeal. Against that, my lord, they filed an appeal before division before the deputy commissioner at annexure H, my lord. Order it annexure H. Deputy commissioner.
You filed the appeal before the assistant commissioner
Yes, my lord, claim to be allowed.
in the year 2022-23,
Yes, my lord.
questioning
Question the mutation standing in the name of third respondent.
dated,
That is, the order is my lord. The 15/3/23 the order, my lord.
huh?
15/3/23 the order of the assistant commissioner.
Allala, the mutation entry that you challenged,
Mutation, we also kindly say 75/92/93.
Huh?
75 of 92/93.
92-93,
ಅದು ವಿಚಿತ್ರವಾಗಿದೆ, ನಮಗೆ ನೋಟಿಸ್ ಇಲ್ಲ. ವಿಲಾಸ ಕಳಿಸಿ annexure A. It is typed copy at page 14. And ವಿಲಾಸ, it is honored, this is the first time I'm coming this type. ಅರ್ಜಿದಾರ ಭಾರತೀಯ ಅರ್ಜಿ ಮೇರೆಗೆ ಖಾತೆ ಆಗಲು ಖಾತೆಯನ್ನು ಭಾರತೀಯರ ಒಪ್ಪಿಗೆ ಹಾಗೂ ಹೇಳಿಕೆ ನನಗೆ ತಂಗಿ ಹೆಸರು ಮಾಡುತ್ತಾರೆ. ಅವರೇ ಖಾತೆದಾರ, ಅವರೇ ಹೇಳಿಕೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಏನು?
ಅರ್ಜಿದಾರರಾದ ಭಾರತೀಯವರ ಅರ್ಜಿ ಮೇರೆಗೆ ಖಾತೆ
ಎಲ್ಲಿ, where are you reading?
page 30. Typed copy that about 14.
ವಿಭಾಗ ಪತ್ರ,
ನಮಗ್ ರಿಜಿಸ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ, ನಮಗಾಗಿದೆ, ಲ್ಯಾಂಡ್ ನಮಗ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಹಾ?
ನಮಗ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ರಿಜಿಸ್ಟರ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ. I produced annexure B, the register partition. My sister, the court respondent, go to the Tahsildar and makes that 8 guntas fall into my share. Now the statement will also kindly see, this is the first time I come to share. ಅರ್ಜಿದಾರ ಭಾರತೀಯರ ಅರ್ಜಿ ಮೇರೆಗೆ ಖಾತೆದಾರ ಭಾರತೀಯರು ಒಪ್ಪಿಗೆ ಆಗಿ ಹೇಳಿ ಅವರೇ ಖಾತೆದಾರ, ಅವ್ರಿಗೆ ಹೆಸರು ಮಾಡಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಕ್ಚುಲಿ ಐ ಆಮ್ ದಿ ಖಾತೆದಾರ.
ಮ್ಯೂಟೇಶನ್ ಎಂಟ್ರಿ annexure C ಓದ್ತಾ ಇದ್ರ ನೀವು?
annexure A ಓದ್ತಾ ಇದ್ದೀನಿ ನಾನು.
annexure
A ಓದ್ತಾ ಇದ್ದೀನಿ.
92-93.
ಅರ್ಜಿದಾರ ಭಾರತೀಯರ ಅರ್ಜಿ ಮೇರೆಗೆ ಖಾತೆ ಆಗಲು ಖಾತೆದಾರರಾದ ಭಾರತೀಯರ ಒಪ್ಪಿಗೆ ಹಾಗೂ ಹೇಳಿಕೆ ಮೇರೆಗೆ ತಂಗಿ ಹೆಸರಿಗೆ ಖಾತೆ ಆಗಬೇಕಂತ ಅಂಗೀಕರಿಸಿದೆ ಅಂತ. ಅವರೇ ಅರ್ಜಿದಾರ, ಅವರೇ ಹೇಳಿಕೆ ಕೊಡೋದು. ಐ ಆಮ್ ದಿ ಖಾತೆ ವಿತೌಟ್ ನೋಟಿಸ್ ದ ಪಾಸ್ಟ್.
It's all right, but the mutation entry is of the year 1992-93.
Because I am not aware of that.
You cannot say you are not aware.
That the question is no, after partition, register partition day, it come to my share. Therefore, my lord, I approached the deputy assistant commissioner. Assistant commissioner allowed my appeal. And my lord, based on that, my lord, she made an application 4 days, mutation 4 days also. That also a question for the assistant director of land record. Even that's also allowed. That's attained finality. That in at page annexure D, page 34. That's not the attained finality. The mutation code made in favor of the third.
ಅಲ್ಲ, ಅವರು ಅಪಿಯರ್ ಆಗಿದ್ರಾ?
ಅವ್ರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ. ಅವ್ರ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಹಾಗೆ ನಮ್ಮ ಹೆಸರು ಮಾಡೇ ಇಲ್ಲ, ಸೆಟಿಸ್ಫೈಡ್ ಮಾಡಿದ್ರು. ಈಗ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆರ್ಡರ್ annexure H ಮೇಲೆ page 30, page 56, 58.
ಎದುರುದಾರರ ಪರ ವಕೀಲರು ಗೈರು.
That I have not questioned. Now, only question is before the deputy commissioner, my lord, at annexure H, my lord. Reasons will also kindly say at page 61. 61. ಉಪಾಧಿಕಾರಿ ಉಭಯತರು ನೋಟಿಸ್ ನೀಡಲಾಗಿದೆ. ವಿಚಾರಣೆ ಅಭ್ಯರ್ಥಿಗಳು ಸೇಸ್ ಉಪಾಧಿಕ ದಿನಾಂಕ 22/3/23 ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು, ಅದೇ ದಿನ ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸಿ ಆಲಯ ರುಜು ನಡೆದಿದ್ದಾರೆ ಅಪೇಕ್ಷಣೆ ಸಲ್ಲಿಕೆಗೆ ಆಹ್ವಾನ ನೀಡದೆ ಒಂದೇ ಒಂದು ದಿನಾಂಕ ನೀಡೋದ್ರಿಂದ ಆದೇಶಕ್ಕೆ ಕಾಯ್ದಿರಿಸುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ 4
ಸಾಕಲ್ಲ, ಅಷ್ಟೇ ಸಾಕಲ್ಲ.
ಅಲ್ಲ, ಅದು ಆಕ್ಚುಲಿ ತಪ್ಪದು, ಉಲ್ಟಾ ರಿವರ್ಸ್ ಬರೆದಿದ್ದಾರೆ. 22/2ಕ್ಕೆ ಕೇಸ್ ಕರೆದಿದ್ದು 22/3 ಅಂತ ಬರೀತಾರೆ. ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಆರ್ಡರ್ ಶೀಟ್. Therefore its reasoning of the deputy commissioner is wrong. So So the question of remanding does not arise because it is a partition deed has gone.
He has remanded the matter.
Remanded matter ಮಾಡಿದ್ರೆ ನಮ್ಮ ಹೆಸರು ಖಾತಾ ಇದೆ ಚೇಂಜ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ನಮ್ಮ ಹೆಸರು ಖಾತಾ ಇದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ.
You have questioned the mutation entry after 25 years.
I have no notice, my lord. That's the reason. You are asking.
You can't say you had no notice at all.
Right.
In respect of a mutation entry,
Right.
you can't say I had no notice at all.
Well, last week I say registered partition.
Anyway, it has only been remanded.
My request is only let the party make the step because RTC already entered my name. ನನ್ನ ಹೆಸರು ಬಂದ್ಬಿಟ್ಟು I produce RTC, my lord.
Learned AGA, HCGP takes notice for response number 1 to 4.
David Conrad, sir.
Issue notice to respond number 5. Learned counsel for the petitioner is directed to serve copies of the petition along with annexures on the learned HCGP.
The annexure F1, my lord. RTC ನಮ್ಮ ಹೆಸರು ಅಲ್ಲ change
He has remanded the matter, sir.
ಅಲ್ಲ RTC change ಮಾಡಿ status quo ಇದೆ
Yes.
ಸಾಕು ಎಂಟ್ರೀಸ್ ಅಷ್ಟೇ ಇನ್ನೇನು ಬೇಡ.
Yes.
Otherwise, my lord, tomorrow the alienate and changes ಆಗ್ತದೆ. ಅಲ್ಲ ನನ್ನ ಹೆಸರಿಗೆ ಆಗ್ಬಿಟ್ಟಿದೆ annexure F ಅಲ್ಲಿ.
ಅದೇ ಆರ್ಡರ್ ಮಾಡಿದ ತಕ್ಷಣ ನೀವು ಹೋಗಿ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ?
Therefore, lordship might at least.
Yes.
Serial number 16.
For the petition. I have challenged the annexure L that the impugned notice and impugned proceedings initiated by the respondent number 3 against this petition and also seeking for writ of prohibition not to pass any order till disposal of the writ appeal. On the same subject matter, they have filed the one more revenue appeal before the respondent number 3. Consider the annexure.
Wash annexure L.
L.
Notice before 136 to notice they are challenged.
Notice.
Notice and proceedings also. Already
140?
141 annexure L. The latest revenue appeal filed by the respondent number 5 to 10 against this petition.
Is earlier petitions?
Earlier order was passed. Kindly see the annexure D. On the same subject matter, the respondent number 3 has passed the order. Annexure D, the ink page number 59 in the same subject matter. Said order was challenged before.
Has called in question the show cause notice issued by the BDA under section 17.
No, annexure D. Annexure D.
What is this earlier writ petition? Annexure
On the same subject matter, the respondent number 5 to 10 has filed the appeal before the respondent number 3. After passing the order, I have challenged.
Respondent number 3, respondent number 4 andre ನನಗೆ
3
ಗೊತ್ತಾಗಲ್ಲ.
with the assistant commissioner. Against that order, I have challenged before the respondent number 4, that the special DC. Against the both order, I have filed the writ petition before this honorable court. In the writ petition number 7284 of 16, annexure F.
Page?
Ink page number 76. Filed by this petition. Said petition was allowed and direct the Tahsildar to restore the revenue entries in favor of the petition. Against that order, the respondent number 5 to 10 has filed the writ appeal before this division bench.
One nimsha. I have not even seen what is that order.
Please.
You are running.
Annexure F 76. Set aside the earlier AC and DC order in that writ petition. That is the annexure D and E.
Against that order,
Ah.
respondent number 5 to 10 has filed the writ appeal
Hmm.
before the division bench. Same was pending. And the
Pending.
annexure came,
Is still pending.
still pending.
Ah.
Status quo was passed in respect of the revenue entries. Kindly see the annexure came, ink page number 140.
Hmm.
In the meantime, again the respondent number 5 to 10 are filed the revenue appeal before the AC. That is the annexure L. Hence I am seeking for cost the same.
Again they have filed.
Again they filed same survey number.
Annexure?
L. The present proceedings. Still status quo order is effective.
ಯಾರ್ ಫೈಲ್ ಮಾಡಿರೋದು ಈಗ?
Respondent number 5 to 10. Please, 142.
ಕೆ ಮಹಾಲಕ್ಷ್ಮಿ,
Yes, madam.
ಕೆ ರಮಾಮಣಿ,
Yes, ma'am.
ಶ್ರೀನಿವಾಸಾಚಾರ್, ಮಮತಾ. Under 136.
Yes, madam. Yes, madam. Same.
ಎಲ್ಲಿದೆ? Where do you get all this? 136 2.
140. 136 2, madam. Ink page number 141. Madam.
ಕೃಷ್ಣಮಾಚಾರ್.
ಹೌದು. Earlier order was not come to concluded yet, madam. Still in writ appeal was pending. In the meantime, they have filed the one more proceeding.
ಇದೇನ್ರಿ ಇದು annexure H ಅಲ್ಲಿ ಇದೆ? Writ petition?
Against the this petitioners, the one more BDA proceedings was held, and against that order, one more petitioner has filed the petition before the honorable court in the annexure J. In that petition also, the not to precipitate order was passed.
For violating provisions contained in section 17(4). ಅದು ಬೇರೆ.
Yes. J.
136, page number 136.
J.
Page 136. Annexure K.
In respect of the same survey number, the petitioner also get the order not to precipitate the order.
To BDA.
Although still there is the effective, which is also pending. In that writ appeal, this AC was arrived as a respondent number 8. The respondent number 5 to 10 are suppressed these earlier proceedings and filed the one more appeal before the AC.
BC Mamta. Her name is there at serial number 33. In page number 84. BC Mamta.
Please. They are the site purchaser in that survey number.
ಅಲ್ಲ ರೀ, ಇವಾಗ ಅಪೀಲ್ ಹಾಕಿರೋದ್ರಿ. ಇವಾಗ ಅಪೀಲ್ ಹಾಕಿರೋದ್ರಲ್ಲೂ ಯಾರೋ ಮಮತಾ ಅಂತ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
Yes, yes, ma'am. That is a different one.
ಅವ್ರು ಬೇರೆನಾ?
ಅವ್ರು ಬೇರೆ sir.
They were not.
And the in page number 78, ma'am. 7A. The present respondent here.
78.
78. 7A. There is a Mamata.
ಅವ್ರೇನಾ?
ಹೌದು.
ಪುನೀತ್.
ಪುನೀತ್.
ಸೇಮ್ ಪರ್ಸನ್ ಸಾ?
ಸೇಮ್ ಪರ್ಸನ್ ಸರ್. ಫೈಲ್ ದಿ ಒನ್ ಮೋರ್.
ಮಹಾಲಕ್ಷ್ಮಿ.
ಹೌದು.
ರಮಾಮಣಿ. ಶ್ರೀನಿವಾಸಾಚಾರ್.
ಹೌದು.
Padmanabhachar. Same person, sir.
Oh, same persons earlier also filed, and their order was still pending before the writ appeal. Once again, they have filed this fresh appeal.
HCG takes notice for respondents number 1 to 4. Issue notice to respondents number 5 to 11. Learned counsel for petitioner is directed to serve copies of the petition along with annexures and the learned HCG. Stop. Next para. Learned counsel for the petitioner submits, while drawing the attention of this court to annexure F, an order passed by this court in WP number 7284 of 2016 dated 20th of July 2022, wherein the private respondents number 5 to 10 are respondents number 4 to 7C. In the said writ petition, ಆಮೇಲೆ ಇವರು ಜಯಂತಿಲಾಲ್
They are the
Talecha.
he is also revenue entry holder, along with the petitioner. He is also along with the petitioner.
ಆ petitioner ಅಲ್ಲಿ ಇವ್ರನ್ನು ಪಾರ್ಟಿ ಏನ್ರಿ?
ಇದಾರೆ.
ಎಲ್ಲಿ ಯಾವ್ದು ನಂಬರ್?
Consider
ಜಯಂತಿಲಾಲ್ ಸಲೇಚಾ.
yes. Consider in page number 141. Proceedings. Reference number 7.
ಈ annexure F ಅಲ್ಲಿ ಈಸಿ ಎ ಪಾರ್ಟಿ ಅಂತ ಕೇಳ್ತಾರೆ.
He is in party. He is not made a party. Illa. But in AC proceedings, he is in a party.
Learned counsel submits that in the said writ petition, the petitioners herein had challenged the orders passed by the assistant commissioner and the deputy commissioner, who had set aside the mutation entry made in favor of the petitioners. Full stop. This court held that Patel Anjaney Gowda had secured title over the lands in question under sale deed executed by the civil court, which was also registered, and he became the absolute owner of the lands in question. Full stop. The legal heirs of Patel Anjaney Gowda executed registered sale deed dated 19/8/1992 in favor of the petitioner and Jayanti Lal. Full stop. Therefore, the conveyance of title from Sanjeevachar to Patel Anjaney Gowda and thereafter to the petitioner and Jayanti Lal being clear and complete, no other person would have any right to question this flow of title from Sanjeevachar to the petitioner and Jayanti Lal. Full stop. Accordingly, the writ petition was allowed and the impugned orders passed by the assistant commissioner and deputy commissioner have been set aside. Full stop. The private respondents therein have filed an intra-court appeal in writ appeal number 949 of 2022, and the same is pending consideration before the division bench. Full stop. In the meanwhile, similar appeal invoking section 136 bracket 2 is again filed by the respondents herein before the assistant commissioner, and therefore the petitioners are aggrieved of the impugned notice issued by the assistant commissioner. Full stop. Next para. Consequently, there should be an ad interim order of stay of the impugned notice at annexure L and all further proceedings pursuant to the impugned notice.
Annexure L.
Proceedings bearing number
RAB. RABNT 21/24.
bar BNT dash 21 of 2024 shall stand stayed till the next date of hearing.
Number 17, Abhishek Kuddar.
Lords, the present petition is filed, my lord, seeking mandamus against the respondent number 1 school, which is Jawahar Navodaya Vidyalaya, my lords, to admit the petitioner. Lords, the brief facts are, my lords, the petitioner, my lords, applied for the admission to the Navodaya Vidyalaya schools, my lords. And thereafter, my lords, he wrote exam for entrance exam on 18/1/2025, my lords. But thereafter, my lords, till June, results were not announced by Jawahar Vidyalaya school. As such, my lords, the petitioner got admitted to Morarji Residential School in Hassan. My lords, while he attended 36 days in the Morarji Desai Residential School, my lords, on 11/7/2025, the principal of Jawahar Navodaya Vidyalaya, my lords, who is respondent number 1, issued a letter to petitioner saying that he has been provisionally selected for the Jawahar Navodaya Vidyalaya school and he has to submit his documents by 16/7/2025, my lords. Thereafter, my lords, on 15/7/2025, before, my lords, submitting documents, the principal of the Jawahar Navodaya Vidyalaya school, my lords, himself issued a letter to the Morarji Desai school where petitioner was admitted, asking to provide the transfer certificate. As per the request of the principal of the school, my lords, respondent number 1, the Morarji Desai school, my lords, has issued transfer certificate, my lords, on 16/7/2025. Lords, after 3 days of issuing of transfer certificate, on 19/7, my lords, the respondent number 1 school says that, my lords, the provisional selection has been cancelled and the petitioner is required to leave the school. As such, my lords, agreed by the action of the respondent number 1, my lords, the petitioner is before this honorable court. My lords, may kindly take, my lords, annexure C, my lords, at page 18. At page 18, my lords, is the letter issued by the principal, my lords, of the Jawahar Navodaya Vidyalaya to the petitioner, saying that, my lords, the petitioner is provisionally admitted to the respondent number 1 school.
Where is that?
My lords, at annexure C, page 18, my lords. This is to inform you that your son, Master so-and-so, roll number so-and-so, has been provisionally selected for admission into class 6 in the Vidyalaya during session 2025-2026 through Jawahar Navodaya Vidyalaya selection test 2025. And also, my lords, is entitled to get admission after fulfillment of prescribed conditions. My lords, is the communication issued by the principal of the Jawahar Navodaya Vidyalaya school.
Which is the impugned order now?
My lords, impugned order is annexure, my lords,
F.
C only, my lords. They are seeking admission based on annexure C. My lords, they have issued annexure, my lords, F, my lords. At my lords, page 37, my lords. Dated 19/7/2025.
Discrepancy relating to the parent's name
and block
in the application. However, a more serious issue, the block mismatch was not disclosed by yourself at the time. Only if they apply from the same block in which they are studying in class 5. Further, as per NBS rules, if any discrepancies are found at any stage during the verification process, the admission of the student is subject to cancellation. For studying in a school located in Hole Narsipura block, where the JNVST application was submitted
From Hassan block.
from Hassan block, this is clear violation.
My lords, before my lords issuing this communication, my lords may kindly take my lords page number 21, which is annexure D. My lords, this is a letter, my lords, issued by the respondent number 1 to Morarji Desai Residential School. There, my lords, the respondent number 1 has stated, it is to inform you that Master so and so, Master Vedant BG, son of Punit Kumari BS of your school, has been selected for admission, class 6 through JNVST 2025 roll number.
Correct, sir. That is not disputed.
That is not disputed.
That is not disputed. Now they are saying clearly the reasons for subsequently cancelling the selection.
Lords,
what do you have to say?
Lords, initially, my lords, they have informed us, my lords, that all the documents are in proper perspective, my lords. They have also obtained.
Now they have pointed out to the rules, and they are saying if you are from some other block, you will not be eligible. What do you have to say about that?
Lords, the grievance is, my lords. Firstly, my lords, I took admission in Morarji Desai School and I attended 36 days.
That cannot
thereafter,
be a
my lords, thereafter, my lords, they themselves have obtained TC, my lords. I left the previous school. Now I am before this school, my lords. After 3 days, they say your admission is cancelled, my lords. The second school which has changed, my lords, in 40 days. In the similar matter, my lords, this honorable court, my lords, in produced annexure, my lords, in WP number 33304 of 2019, my lords, has held, my lords, the best interest.
Copy?
Yes, my lords, at annexure, my lords, page 46, my lords, of my petition. Cross seam. The claim for admission of the petitioner in WP number 41774 of 19 was placed in abeyance because of the pendency of claim of the petitioner in the companion writ petition, in which direction is being issued for admitting the student for the next academic year, that is 2021-2022, and therefore there is absolutely no impediment for confirming the admission of the student in WP number 41774 of 2019, since he has been provisionally admitted to the respondent Navodaya school for the current academic year. Disturbing him otherwise also is not in the best interest of the student. In the present case, my lords, the petitioner has changed already 2 schools. First is Morarji Desai, my lords, and thereafter, my lords, in the petitioner school, the respondent number 1 school, my lords. In the 40 days, my lords, 2 schools have been changed. And my lords, the writ petitions filed by the students, my lords, were allowed by this honorable court, keeping in mind the best interest of the student. Also, my lords, in the said judgment, my lords, there was block mismatch also, my lords. The student studied in Kodagu and Mandya, my lords, and thereafter it applied for the entrance test. And he was also provisionally selected, my lords, and thereafter, as admission was cancelled, my lords, he approached this honorable court.
Central government council appear ಆಗ್ತಾರೆ ಇದಕ್ಕೆ.
Yes, my lords, he has been served.
Huh?
He has been served, yes, my lords. So, respondent number 2, my lords, is the Department of School and Literacy, my lords, governed by ministry. And my lords, they, my lords, administer the Jawahar, I mean, the Navodaya Vidyalaya schools across various states in India, my lords.
ಇವರು ವಿ ನರಸಿಂಹಹೊಳ್ಳ.
Please, my lords.
Yes,
Has
ವಿ
been-
ನರಸಿಂಹಹೊಳ್ಳ.
the previous petition he has appeared.
Learned Counsel Shri V. Narasimha is requested to take notice for respondent number 1. Learned Central Government Council is requested to take notice for respondent number 2. Learned AGA takes notice for respondent number 3. Learned Counsel for petitioners is directed to serve copy of the petition along with annexures on the learned counsels for the respondents. We'll stop. Next para. Learned Counsel for the petitioner submits that at annexure C is the provisional admission of the petitioner to 6th standard at the Jawahar Navodaya Vidyalaya, Mavinakere, Hassan. Where the petitioner is said to be entitled to get admission after fulfillment of prescribed conditions. Full stop. The petitioner was asked to report to the school along with documents mentioned in the notice for verification on 16/7/2025. Full stop. Thereafter, the petitioner was admitted.
Yes, my lords, he was asked to furnish documents.
Then
Thereafter, my lords, at annexure D, my lords, the principal of the school, my lords, has issued letter to my previous school, Moraji Desai School, to give transfer certificate of the petitioner.
Thereafter, the first respondent has written to the principal of Morarji Residential School,
Baraguru,
Hassan District, at annexure D, to issue transfer certificate for admission of the petitioner herein to the respondent school. Full stop. Accordingly, transfer certificate has been issued.
At annexure E, my lords. At annexure E, they have
At
issued.
annexure E. Stop. At this stage, the impugned order at annexure F dated 19/7/2025 has been issued by the first respondent, stating that the provisional admission of the petitioner is cancelled for the reason that the petitioner studied in a school located in Hole Narsipura block.
Parental misinformation. ತಾಯಿಯವರ ಹೆಸರು ಮಿಸ್ಮ್ಯಾಚ್ ಆಗಿದೆ ಅಂತ ಪೇರೆಂಟಲ್ ಮಿಸ್ಇನ್ಫಾರ್ಮೇಶನ್. Parental
and whereas the school in question is situated at the Hassan block, and in terms of the rules governing the admission, a student who has studied in another block will not be eligible for admission in another block. Full stop. However, learned counsel submits that under similar situation, this court in WP number 33304 of 2019 and 41774 of 2019, by order dated 10th of November 2020, set aside such endorsements and has issued a writ of mandamus regularizing the admission of such students. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order at annexure F till the next date of hearing, and with a direction to the first respondent what is your interim prayer?
My lords, to allow the petitioner to attend classes, my lords, and also to restrain the principal, my lord, respondent number 1, to not to admit any other person, my lords, in place of the petitioner.
To allow the petitioner to attend classes and continue his studies in class 6 at respondent number 1 school, comma, until further orders.
Yes, my lords. In my place, my lords, no other candidate is.
How can when you are attending classes, how can they appoint some other?
Yes, my lords. Not possible. Please, oblige me.
Yes.
Serial number 18, A.K. Vasanta.
Appear for the petitions in this case, my lord. With respect to the.
Yes.
This honorable court, first the order in annexure A, page number 15, my lord. With respect to the petitioners and other students, along with respondent number 5, prepared this writ petition to allow them to appear in the examinations. Accordingly, relevant para is at page number 27. Relevant. May I read, my lord? At this juncture, learned counsel appearing for the petitions has submitted that the supplementary examination fee shall be payable by the unsuccessful students for the ensuing examination by 3/7/2025. In that view of the matter, the respondent number 2 and 3 are directed to announce the result of the petitioner's students hearing in terms of the order dated 30/6/2025. Consequently, the results were announced, my lord. Now, once again, the timetable has been given in annexure J, page 41. And we have paid, the petitioners paid the examination fee for supplementary examination. We have filed in their certain subjects. Now, their hall ticket has not been given to the petitioners. That being the fact, tomorrow the examination is going to start. And we will be put to very great hardship, my lord. And also, according to the order of this honorable court in the writ petition 664 of 2025, dated 2/7/2025, we have paid the fee, but respondent number 3 is not issuing the hall tickets to the petition's hearing.
Lord, for not issuing the hall tickets, there are reasons, my lord. As per annexure H, my lord, they made a request at page 40. They made a request to generate user ID, password to registered email ID as furnished before. So on. So the third respondent has got out and inspected the school, my lord. After the inspection, it is coming to their knowledge, saying that there was that school is existing at all, my lord. NB Institute was not at all there. That's why they made a recommendation to cancel the NOC issued by the authority.
My lord, annexure H, dated 9/7.
Because as and when they want to change the user ID, definitely there is a change in management. As and when they want to change in management, it should be brought to the notice of the authorities. Here, there is no such information. Nothing is forthcoming from the petitioner to the respondent authorities for change of administration. And we come to know that they have entered some MOU with some third parties and running the institutions. And after verification, it is come to their knowledge saying that that school was not at all in existence.
Who are these petitioners number 1 and 2?
Students, my lord.
All are students.
All are students.
63 years.
It is very erroneously mentioned, my lord.
Huh?
It's not, it is 20. Yeah, for
B, because it is a B form.
for
There
D
is
form
no
of education, the age is not limited. It's
criteria.
not-
Anybody can take examination to get the
B form.
certificate of
D form.
D form.
D
D
form.
form.
So they are students only.
Please, my lord.
They are students.
Please, my lord.
Students are before this court.
And earlier writ petitions also, all these petitions are before this court. There also they have not successful in passing the examination. Now they are coming before this, again before this court to write, seeking permission to write the supplementary exam. There, that itself shows that there was not at all college is running in the name of the NB Institute. That is the inquiry report says.
But annexure H came to be given by on 9/7/2025, my lord. Till today, they have not, respondents have not answered to, replied to the annexure H, my lord. Now they are coming with the, this question that we are not running the educational institution there.
We are you are students.
We are students, respondent number 5. Sorry, my lord. Respondent number 5.
So, but the respondent number 5 is required to answer.
Please, my lord. But we are now put to hardship, my lord.
Now the previous order that you read,
please, my lord,
is a petition filed by you only.
Please,
by the same petitioners.
Yes.
Petitioner, same petitioner.
Same petitioner.
Along with other students.
Al 61 ಇಲ್ಲಿ 49 ಇದೆ.
There 60 students and here 40 students. 48 students. Some of the students already got passed. These petitions are failed in some of the subjects.
Supplementary exam.
Please, my lord.
61 in 48. And the report clearly says, my lord, there was no such school is in existence. In that place, some PU college is running. The photographs
ಹೌದಮ್ಮ, ಇವಾಗ previous order ಅಲ್ಲಿ they have been permitted to write the supplementary exam.
No, they have permitted to pay the school fees. That is a supplementary examination.
Supplementary exam ಗೆ.
Later, they have made a representation.
They have taken up the supplementary exam. Some of them have failed again.
Please, my lord.
There also with heavy resistance only petition came to be allowed. Then we conduct an inspection. There it reveals that the such institutions not at all there.
What will you do with the students who have already taken up the exam?
We can provide alternative schools to write the examination.
ಇವಾಗ ಎಲ್ಲ ಆಗುತ್ತೆ? ನಾಳೆ examination ಇಟ್ಕೊಂಡು ಇವಾಗ ಹೆಂಗ್ ಆಗುತ್ತೆ?
Externally ಕೊಡಬಹುದು. Because they have not successful candidates. 61 members
that is why,
they have failed.
That is why they are seeking to write the supplementary exam.
Yes, ma'am. But
if it is not permissible in law for them to write the supplementary exam, then you can make out a case.
Yes, ma'am.
But that is not the issue. You are talking of the recognition granted to this institution.
Because they have
It should not have been granted because for obvious reasons.
Anomaly, my lord. In the last writ petition also we resisted because the principal, the Delhi organization has refused to give grant to run the institutions, permission to issue, did not issued license. Thereupon, after the request, late fee was paid and taken permission to write the examinations. Then again, after receipt of the annexure H, we inspect the college, then come to know that there was no such college at all. So then we have made a recommendation to cancel the NOC issued by the authority.
ಹೌದಮ್ಮ, ಇವಾಗ ಈ ಎಕ್ಸಾಮ್ ಬರ್ದಿದ್ರಲ್ಲ ಮಕ್ಕಳದು ಅವ್ರು ಏನಾಗಬೇಕು ಇವಾಗ?
Is their fate. R5 has to answer it. R5 has to answer it. School college responsibility.
ಬರ್ಕೊಳ್ಳಿ.
And some unconnected persons requested the authorities to issue passer user ID, my lord. We have all once at once we will give the user ID. Now they are again making request at annexure H to issue the user ID from a different persons. rule mandates, my lord, as and when the administration changes, it is the mandatory on the part of the institution to inform the authorities for change of administration. That is not being done in this case, my lord.
The request is made by the principal.
But he is no way connected because we have issued the, my lord, I have produced the documents, my lord. Yes, right now. We have given permission in the year 2019 to one Ideal Vidya Samsthe run by some lady, my lord. It is at page 2, my lord. We have issued permission. For them only we will give user ID. Now they have entered into an MOU. That also I have produced the document, my lord. That is the fifth document, my lord. MOU. It is they have entered MOU on 21/2024 with some lady, Nasima Banu. She has entered MOU with BVR group of institutions run by Rohini BV. If any changes in the administration, definitely it has to brought to the notice of the authorities. It is the mandate of the rules, my lord. That's why they were asking them now the fresh user ID. My lord. Karnataka educational institutions change in the governing council or changes in the location or private educational institution rules mandates that requirement. As and when change in administration, it should brought to the notice of the authorities and take NOC from the concerned authority. That is not being done in this case, my lord. That's why last occasion also the authorities have refused to issue a license to run the institution. Somehow at the end of the year, they have taken the permission and without no alternative, this court has passed the order to write the examination. But later part, we come to know that school was not at all in existence.
SS Haveri for Pharmacy Council of India.
Yes, Haveri, the panel council of R1.
Learned Council. Shri SS Haveri is requested to take notice for respondent number 1. Learned AGA takes notice for response number 2 to 4. Issue emergent notice to respond number 5. Learned Council for petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next para. Learned Council for the petitioner submits while drawing the attention of this court to annexure A, an order passed by this court in WP number 664 of 2025, dated 2nd of July 2025, comma, that in respect of the same petitioners and a few more, please, comma, this court directed the respondents to permit the petitioners to appear in the supplementary examination by collecting necessary fee. Full stop. Learned counsel submits that these petitioners have taken up the supplementary examination and since the petitioners have failed in some papers, comma, they are seeking further direction to permit the petitioners to take up the supplementary examination, which is scheduled to commence on 30/7/2025. Full stop. Next para. Learned AGA submits that the situation insofar as respondent number 5 institution is concerned has further complicated, comma, since admittedly in terms of annexure H, a request is made by the principal of the institution to generate a fresh user ID and password to enable the students to enable the institution to issue hall tickets to the students. Full stop. However, on inspection, it is now found that the management has changed and some unknown persons are now seeking the generation of a fresh ID, user ID and password. Full stop. Learned AGA submits that the rule requires that whenever there is a change in the management, it has to be informed to the concerned authorities. And no such information is given by the fifth respondent institution. Stop. Next para. Having regard to the urgency of the matter where the supplementary examination will commence tomorrow, comma, and having regard to the admitted fact that the petitioners herein were permitted to take up the supplementary examination, comma, the interim relief as sought by the petitioners is required to be given to the petitioners. Full stop. Next para. Accordingly,
Court says that there was no school at all.
huh?
Not only management, there was no school at all. That is the report says.
That is why I asked you what should happen to the supplementary examination that they have written now.
They have to wait for other 6 months. We will got admitted to different schools.
ಅಲ್ಲಮ್ಮ ಈಗಾಗಲೇ ಸಪ್ಲಿಮೆಂಟರಿ ಎಕ್ಸಾಮ್ ತಗೊಂಡಿದಾರಲ್ಲ ಅವರೆಲ್ಲ ಇವರೇ ತಗೊಂಡಿದ್ದಾರೆ ಕೆಲವು ಪೇಪರ್ ಅಲ್ಲಿ ಪಾಸ್ ಆಗಿದ್ದಾರೆ ಏನಾಗ್ಬೇಕು
That is also through court order only they got successful to get the permission. Now also they are doing the same thing. And there is no end to put.
Therefore, what we can do is prevent fresh admission. ಯಾರಾದ್ರೂ ಬಂದು ಇಲ್ಲಿ admission ಗೆ
My learned
direction ಕೊಡಿ ಅಂದ್ರೆ we can say no, you go to some other school ಅಂತ ಹೇಳ್ಬೋದು.
ಇಲ್ಲ ಸ್ಕೂಲೇ ಇಲ್ಲ ಎಲ್ಲಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತಾರೆ ಅಂತ.
Correct.
My learned
ಅಲ್ಲ,
sister
we
herself
don't
produced
know-
the photography.
Where the examination will be conducted. It may not be in the same institution.
Yes,
It
in a
may be in
different
some other
way.
institution.
Yes, ma'am. If it comes to admission of students,
Ah.
definitely we have got alternative
Correct.
method. to
Admission
admit.
ಗಾದ್ರೆ if the prayer in the writ petition was regarding admission, we could have simply said no, this institution is appears to be non-existent and therefore you go to some other school ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು.
And even for user ID, my lord, that is also one of the fault on the part of the school. They have changed the administration without to the notice of the authorities.
Yes.
We cannot now issue fresh ID, my lord. That is the biggest problem for us to issue all ticket.
Consequently, the respondents number 1 to 3 are directed to enable the petitioners to take up their supplementary exam which commences from tomorrow, comma, by issuing all tickets
Please, ma'am.
to the petitioners. Full stop. For that purpose, if a fresh user ID and password is required to be given to the institution, comma, the same shall be given, comma, subject to the final outcome of this writ petition. Yes.
My lord, hand delivery of the order.
Yes.
Grateful to the son.
Serial number 18, V. Shivakumar.
Head. The PTCL Act, the Assistant Commissioner rejects the application for restoration on two grounds. One, that there is a conversion. Number two, 43G, grow more food scheme, it cannot be considered. The Deputy Commissioner set aside the Assistant Commissioner's order and allows the petition, orders restoration. Annexure A is that order. And nothing is considered with the Deputy Commissioner with regard to whether it falls under the grow more food scheme or not. The purchase of the property is
Please come to the synopsis.
12/7/1948. Munishami, some of
Grantor.
Marappa, he grants, he the grantee. But on 27/1948, Saguali chit was issued. Then on 17/4/82, Munishami died. Then on 13/9/94, he executes sale agreements in favor of Y.C. Satish, that the deceased petitioner. 2/3/95, another petition is filed. Not 3/9/2003, sale deed is executed in favor of the petitioners pertaining to 3 acres 6 guntas.
Sale deed is executed. Sale agreement, registered sale agreement ado.
Registered sale agreement.
Agreement.
Then registered power of attorney. Then the sale deed is executed on 3/9/2003.
ಯಾರು execute ಮಾಡಿರೋದು? ಎಲ್ಲಿ, where is that document?
Sale deed is executed by the power of attorney holder, not he executes the sale deed on behalf of all the persons. And there is a conversion.
Without permission. Without permission.
43G,
you know?
It's a grow more food scheme.
So what? It's a
Grant
land
is under
granted.
grow more food scheme.
Section 4.2 says.
Yes.
You have to have prior permission.
That prior.
So it's a clear violation of section 4.2.
If it's a clear violation, but he had kept quiet for all the number of years. He has come with after several years There is a delay in filing of the petition also.
Ah.
The delay is, not, the sale deed is 2003. The petition is filed after several years. He files it in 2021.
They have not executed the sale deed.
But the power
They have
of
not executed.
they executed
Where
a power
is that
of
sale deed?
sale deed is produced before the court. Sale deed is produced on at annexure page 68.
68.
68. The type copy is at page 75.
68 is general power of attorney.
Yes, power of attorney.
Where is the sale deed?
That I'll just point out. Sale deed is at page 78. He is by the power of attorney holder. By Satish. He sells this entire extent of the land. There was a proceedings under 79 AB and then executes the registered sale. Land is converted on 23/12/2004. Page 89.
So this is executed by Satish Kumar in favor of his wife.
Yes. In favor of his wife.
Yes.
On the strength of the power of attorney. And conversion at page 89 is on 23/12/2004. But he comes after several years, and approaches the authority. The assistant commissioner comes to the conclusion that it's under the Gromore Food Scheme. Number 2, he says that it's a converted land and rejects the application. The deputy commissioner, he sets aside the order on the ground that there is a violation of 443G. That's the only order that came to be passed. These are the material facts that are available. But the deputy commissioner does not assign any appropriate reasons in regard to this aspect of the matter.
If you go on merits, there is nothing wrong in the order. In Guntaya's case,
yes,
Supreme Court has held whether it is Gromore Food or whatever, that cannot be questioned by the purchaser. Now here is a case where the sale deed is executed by the power of attorney holder in the year 2003 without prior permission of the government. Section 4(2) does not make any such distinction, whether it is absolutely granted or granted for upset price. So therefore Supreme Court held it does not lie in the mouth of the purchaser to subsequently say it was granted under this scheme, that scheme, and therefore they could not have imposed such a condition. Although those cases where the sale deeds have happened before the commencement of the act, allene Supreme Court said you can't take up that contention. Here is a case where there is no prior permission of the government. Irrespective of whether it is under that scheme or this scheme or whatever, even after completion of the period of non-alienation, you have not obtained the permission of the government.
Even after the non-alienation period, 2003 sale deed, possession was delivered then only.
You also did not raise such an objection.
That was
regarding delay, you also not raised any objection.
I raised it before the authority. I raised it.
Barker. Learned AGA
Brave
takes
Government.
notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioners is directed to serve copies of the petition along with annexures on the learned AGA. Full stop. Next paragraph. Restoration ಆಗೋಗಿದೆಯಾ?
Restoration agila.
ಆಗಿಲ್ಲ.
Only thing is not mutation entry, page annexure J. He
ಆಗೋಗಿದೆ.
was- No, he only went to get the mutation transferred. It's not restored.
Mutation ಆಗೋಗಿದೆ.
Mutation agila. Yesterday night they were trying to get it done.
What is annexure J?
Annexure J is the recent RTC where there is Sarkara, then the name is mentioned, Satish Kumar's name is mentioned. They are in possession.
ಅಲ್ಲ ಅದನ್ನ ಝೀರೋ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್ಕಾರಕ್ಕೆ ಅನ್ನೋದನ್ನ 3 acres 5 ಗುಂಟಾಸ್
ಮಾಡಿದ್ದಾರೆ.
ಅಂದ್ರೆ ಮ್ಯೂಟೇಶನ್ ಆಗೋಗಿದೆ.
Mutation ಸರ್ಕಾರದ ಹೆಸರಲ್ಲ.
Having regard to the fact that the sale deed was executed on 3/9/2003 and the application was filed before the Assistant Commissioner in the year 2020.
21. 20. Sorry.
And there is a delay of nearly 17 years in filing the appeal before the Assistant Commissioner. There shall be an ad interim order of stay of the impugned orders asked by the Deputy Commissioner at Annexure A till the next date of hearing.
And let them not interfere with the possession.
ಅವೆಲ್ಲ ನಾವೇನು ಹೇಳಕ್ಕಾಗೋದಿಲ್ಲ.
May take a hand delivery of the order.
You will get it tomorrow.
Please.
On compliance for first time.
2 weeks.
Already complaint ಮಾಡಿದೀವಿ my lord.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ my lord.
If office objections are complied, list this matter for preliminary hearing on 5th of August.
Lord, serial number 21, my lord. Lord, in that matter, my lord, the office objection is with regard to non-arraying of the Tahsildar, my lord, who is respondent number 8 in the impugned order. But he is already arrayed as R3, my lord, who is secretary of the Land Encroachment Committee also. So that office objection.
ಬರೋದಿಲ್ಲ. ಅದು ಬೇರೆ ಇದು ಬೇರೆ.
Nagar, I will complain.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Lord, it may be listed next week.
If office objections are complied, list this matter for preliminary hearing on 5th of August.
Obliged.
22.
Small objection, my lord, ಇವಾಗಲೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು.
Same order.
Senior citizenship ಅಂತ ಬರೀ.
Yes. 5th of August. Yes.
23.
Lord, minor objections, my lord.
Same order.
Complaint today itself, my lord.
5th of August.
Please.
24. Ilurdu Mariappa.
79 AB, my lord, covered by.
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
Regarding the court fee, morning itself, I paid the court fee, my lord.
ಅಷ್ಟೇನಾ? ಕೋರ್ಟ್ ಫೀ ಮಾತ್ರನಾ?
And remaining on pagination on it ಮಾಡಬೇಕು.
ಆಯ್ತು ಮಾಡಿ. Let it come up on 5th. Same order. Yes.
25.
Appearing for respondent number 5.
The office objection, lord. Some minor objection, lord. I'll complain. The
Same order.
5th it may be taken.
Yes.
26. Punit C. Punit C.
2 weeks for complaints of office objections.
Withdrawal, serial number 27.
Filing a memo for withdrawal of the report.
learned counsel for the petitioner has filed a memo dated 29/7/2025 stating that the parties have amicably settled the matter and therefore the petitioner does not wish to pursue the writ petition. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
28,
I appeal for the petitioner.
Tick market.
Yesterday I filed a memo in the registry for withdrawal.
Withdrawal.
It may be dismissed as settled out of court.
Same order. Memo dated 28/7/2025. Dismissed as withdrawn.
Orders, serial number 29, Nagaya, non-compliance. Amendment of
2016, man. It may be posted for hearing.
Finally, a week's time is granted to enable the petitioner to comply with the directions issued on 1/2/2023, to amend the cost item. Full stop. Release this matter on 5th of August. Yes.
Serial number 30, CH-07 Rao. Vakalathnama.
A week's time is granted to learned counsel Shri CH-07 Rao to comply with the office objections raised on the Vakalat.
31, Gopi, PM Sidmalappa, second time.
Appeal for petitioner. Needful done
Steps
during the
down.
course of the.
Learned counsel for the petitioners to
This matter,
that steps have been taken. Full stop. Office to verify and issue notice.
In this matter, my lord, mutation proceedings has been challenged. There is a remedy available, my lord, under section 136(2). They have to approach assistant commissioner, my lord. MR has been challenged in the present writ petition.
Verify and submit.
Kindly see the prayer, my lord. Annexure F and G.
Appeal ಹಾಕೋ ಬದಲು direct writ petition.
136(2) remedies available.
2 days time may be granted. I will verify and submit.
Release this matter on 5th of August.
Grateful.
Sir.
list continue ಆಗತ್ತಾ ಅಥವಾ ಪಾಸ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ?
ಸರ್ 26th ಇತ್ತು ಅಟೆಂಡ್ ಬರ್ಲಿಕ್ಕೆ 26th ಏನಾಯ್ತು 26ನೇ ಮ್ಯಾಟರ್ ಅಡ್ಜೆಕ್ಟ್
2 weeks.
2 weeks ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಇಲ್ಲ ಅದು ಇಲ್ಲೇ ಮಾಡ್ಬೇಕಲ್ಲ.
ಸರ್ ಇದರಲ್ಲಿ ಬರೋದಿಲ್ಲ ಅದು. ಇದರಲ್ಲಿ ಬರೋದಿಲ್ಲ. ಈ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಂತ ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮೇಲೆ. ನೋಡಿ ಮಾಡಿರೋದು ಇಲ್ಲಿ ನೋಡಿ PCR ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿರೋದು. ಅಲ್ಲ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನಾನು ಅವ್ರ ಮುಂದೆ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಆಸ್ ಪರ್ ದಿ PCR ಡೈರೆಕ್ಷನ್ ದಿಸ್ ವಾಸ್ ಮೇಡ್. ಇಲ್ಲಿ ತಗೊಳ್ಳಿ ಅದಲ್ಲ ನೀವು ಹೇಳಿದ್ ನನ್ಗೆ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಆದ ನಾನು. It is directed by the in the PCR name was inserted, government name has to be inserted as per direction of the PCR. They have inserted the ಇದು ಅದು ಮಾಡಕ್ ಬರೋಲ್ಲ ಅಂತ ನೀವು ಆರ್ಡರ್ ಜಾಯಿನ್ ಮಾಡಿದೀರಾ? ಇದನ್ನ ಎರಡು ಮಾಡಿದೀನಿ ಅನೆಕ್ಷರ್.
ಅವರು ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಟ್ಟಿಲ್ಲ Annexure F and G ಮಾಡಿದ್ರು.
ಇದು annexure B
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಅವ್ರು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರು ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಬರಲ್ಲ ಅಂತ.
ಅದೊಂದೇ ನಾವು ಮಾತ್ರ ಇರೋದು ಬೇರೆ
ದಟ್ ಈಸ್ ಮೈ ಗ್ರೀವೆನ್ಸ್. ಇದು ಕರೆಕ್ಟ್. ನಾನು ಆಕ್ಚುಲಿ ಪೇಪರ್ ಕೈಲೇ ಓದಿಲ್ಲ. ಸಿವಿಲ್ ಕೋರ್ಟ್
ಅದನ್ನ ನೀವು ಇಲ್ಲಿ ಹೇಳೋದನ್ನ 136 ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಬಂದು ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ.
ಅವನೆಲ್ಲಿ ಮಾಡ್ತಾನೆ? ನೀವು ಅಸ್ಟೆಂಟ್, ಅಯ್ಯೋ ನಿಮ್ಮ ರೆವಿನ್ಯೂ ಅವ್ರು ಮಾಡಂಗಿರ ನಾವ್ ಯಾಕೆ ಸರ್ ಹಿಂಗ್ ಇರ್ಬೇಕಾಗಿತ್ತು?
5th August
ನೀವು ಇಲ್ಲಿಂದ ತಗಲಾಕ ಸಾಕತ್ಲ ಎಲ್ಲರೂ ಹೋಗಿ ಏನಾದ್ರು ಆಗ್ಲಿ ಅಂತ. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಅರ್ಜುನ ಸರ್ ಪಾಸ್ ಓವರ್ ಇದಾವ ಜಾಸ್ತಿ?
ಪಾಸ್ ಓವರ್ ಯಾವ್ದಿಲ್ಲ.
ಇಲ್ಲ, ಬಂದ ತಕ್ಷಣ ಕಂಟಿನ್ಯೂ ಅಲ್ಲ?
Land grant rules to eviction ಇರ್ಲಿಲ್ಲ ನೆನ್ನೆ. ಬರ್ತೀನಿ, ನಮ್ಮೆಲ್ಲ ಕಳಿಸಿದೆ. ಇದೆ ನೋಡಿ, ಅದಿದೆ ನೋಡಿ ಸರ್, ನಮ್ಮಗಳು ಕೊಟ್ಟಿರೋದೆಲ್ಲ ಹೋಗಿ. ಹೋಗಿಲ್ಲ, ಒಳ್ಳೆ ಫ್ರೆಶ್ ಮಾಟರ್ಸ್ ಮಾತಾಡ್ತಾರೆ.
ಸೀನಿಯರ್ ಪ್ರೈಸ್ ಬರುತ್ತೆ ಹಾಕಲ್ಲ ಅಂತ ಯಾರು ಹೇಳ್ತು ಮೆಮೊ ಮೇಲೆ ಯಾವುದು ಕೋರ್ಸ್ ಹಾಕಲ್ಲ ಅದೆಲ್ಲ ಕೊಡ್ಬೇಕು ನಾವು ಈ ತರ ಸ್ವಲ್ಪ ಮೆನ್ಷನ್ ಮಾಡಿ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಇಲ್ಲಿ ತಗೊಂಡು ಹೋಗೋದು ಇಲ್ಲ ನೋಟಿಸ್ ಆಗಿಲ್ಲ after petition are confirmed 1 week from today the petition shall stand dismissed with for 2 days ಆಗಿಲ್ವಾ ಡಿಸ್ಮಿಸ್ ಅಯ್ಯೋ ರಿಕಾರ್ಡ್ ಮೀಟರ್ ಸ್ಟೋರ್ ಮೊದಲೇ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಆಯ್ತು ಮತ್ತೆ ಅದಕ್ಕೆ ಸರಿ ಇನ್ಕಮಿಂಗ್ ಪೋಸ್ಟ್ ಆಗಿರುತ್ತೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೌದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಲ್ಲಿ ಏನು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಪೋಸ್ಟ್ ಆಗಿರೋ ರಿಕಾರ್ಡಿಂಗ್ ಏನಿದೆ ಸರ್ ಇವತ್ತನೇ ತಾರೀಕು ಆರ್ಡರ್ ತೆಗೆದು ಮತ್ತೆ ಆರ್ಡರ್ ಮಾಡಬೇಡಿ ಅದನ್ನೇ ನೋಡಿರೋದಲ್ಲ ಇವತ್ತನೇ ತಾರೀಕು ಬಂದಿರೋದು ರಿಕಾರ್ಡ್ಗೋಸ್ಕರ ಫ್ರೀ ಹಾಕೊಂಡಿರೋದು ಮತ್ತೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಏನು ಪೋಸ್ಟ್ ಆಗಿದೆ ಮತ್ತೆ ನೀವು ಆರ್ಡರ್ ಮಾಡಬೇಕು ನಾನೇನು ಹೇಳಿದೆ ಅದೇ ಪೋಸ್ಟ್ ಆಗಿದೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹೇಗೆ ಅಂತ ತೆಗೆದು ನೋಡಿದೆ ನಾನು ರಿಕಾರ್ಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು ನಾನು ಹೇಳ್ತಾನೆ ಅದೇ ರಿಕಾರ್ಡಿಂಗ್ ಇದೆ ಅದ್ರ ಏನಾದ್ರು ನೋಟಿಸ್ ಆಗಿದೆ ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ನಾಳೆ ಹೋಗೋಣ
The serial number 29.
29.
Thank you, sir.
ಕೊಟ್ರೆ ಇಲ್ಲೇ ಒಂದು ಕರೆಕ್ಷನ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ತೀವಿ ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ ಇಲ್ಲಿ ಕೆಳಗಡೆ ಮಾಡ್ತಾರೆ
ಅಂತ ಹೇಳಿದ್ರು ಬೇಡ ಆಯ್ತು
ಫ್ರೆಶ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದು ಹೋಗಿಲ್ಲಲ್ಲ? ಇಲ್ಲ ಹೋಗಿಲ್ಲ, ಅಲ್ಲಿ ಇಷ್ಟೊಂದು ವೇಟ್ ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಮೆಮೊ ರೆಡಿ ಮಾಡ್ಕೊ ಬಂದೆ ನೋಡಿ. ಚಂದ್ರನ ತಾರೀಖ ಫ್ರೆಶ್ ನಾಳೆ ಅದಕ್ಕೆ ನಾಳೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ನೋಡಿ ಲಿಸ್ಟ್ ನೋಡಿ, ಲಿಸ್ಟ್
ಒಂದ್ ನಿಮಿಷ ಇರಿ ಸರ್, ಯಾಕೆ ಅಷ್ಟೊಂದು ಟೆನ್ಷನ್ ಮಾಡಿ. ನಾವು 30 ವರ್ಷ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೇವೆ.
ಕೊಟ್ಟಿದ್ದು ಹೋಗಿರೋದು. ಈ ಮೆಮೋಸ್ ಇದೆ, ಈ ಬೇಕಾದ್ರೆ ವೆರಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ, ಕಳಿಸದೇ ಇರೋದು.
ನೀವು ಹೇಳಿದ್ರೆ 31 ಅಲ್ಲ, 23 ಅಂತ
ಇಲ್ಲಿ ಮುಂದಕ್ಕೂ ಇದೆ ಅಲ್ಲ, ಇಲ್ಲಿ ನಂಬರ್ಗಳು ಕೊಟ್ಟಿದ್ರೆ ಹೋಗಿರುತ್ತೆ ಸರ್. ಕೊಟ್ಟಿದ್ದು ಯಾವ್ದೋ ಇಟ್ಕೊಂಡಿಲ್ಲ, ಇಲ್ಲಿ ಅಷ್ಟು ಇದೆ ನೋಡಿ. ಯಾವ್ದೋ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಕಳಿಸಿರಲ್ಲ ನಾನು
ನೋಡಿ. ಒಂದು ನಿಮಿಷ, ಅಲ್ಲಿ ಎಲ್ಲಾದ್ರೆ ಹಂಗೆಲ್ಲ ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಕೇಳಲ್ಲ.
ಕರೆಕ್ಟಾಗಿ ಕೊಟ್ಟರೆ ಕಳಿಸಿರ್ತೀನಿ. ಅವರೊಬ್ಬರು IAS ಅದು ನಾನು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಂತ. ಮತ್ತೊಬ್ರು ಏನೋ ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತೀನಿ ಅಂತ ಹೋದ್ರಪ್ಪ. ಈಗ ಕೊಟ್ಟರೆ ಹೋಗುತ್ತೆ.
ಏನೋ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಏನೋ ಒಂದು ಆಗಿರುತ್ತೆ ಸರ್, ಅದನ್ನೆಲ್ಲ ನಮಗೊಂದು 2.5 ಮಿನಿಟ್ ಇನ್ನೊಂದು ರಿಕ್ವೆಸ್ಟ್ ಸರ್, ಪೆಂಡಿಂಗ್ ರೇಟ್ ಬರುತ್ತೆ. ನೋಟಿಸ್ ಆಗಿದೆ. ಏನು ಬಿ ಗ್ರೂಪ್ ಕಂಪ್ಯೂಟರ್ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟು ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು. ನೀವು ಹೇಳ್ತೀರಾ ಸರ್, ಅವ್ರ ಕಂಪ್ಯೂಟರ್ ನಲ್ಲಿ ಚೆಕ್ ಮಾಡಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋದು ಇಷ್ಟನ್ನು. ನೀವು ಹೇಳ್ತೀರಾ, ನೀವು ಫೈಲ್ ಹೇಳ್ಬಿಡ್ತೀರಾ, ಪ್ರತಿಯೊಂದು ಕಂಪ್ಯೂಟರ್ ಸಾಹೇಬ್ ಹೇಳಿದ್ರೆ ಚೆಕ್ ಮಾಡಿ ಅವ್ರು ಇದು ಮಾಡ್ತಾರೆ. ಎಲ್ಲ ಕಂಪ್ಯೂಟರ್ ನಲ್ಲಿ ಎಲ್ಲ ಚೆಕ್ ಮಾಡಿ ಇದು ಮಾಡೋದು. ಏನು ಮಿಸ್ಟೇಕ್ ಇರ್ತದೆ ಅವ್ರಿಗೆ ಗೊತ್ತಿರ್ತದೆ, ಬರ್ತಾರೆ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿರೋದು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಏನೋ ನೀವು ತಿಳಿದ್ರೆ ನೀವು ಹೇಳ್ತೀರಾ, ನಾವು ಹೇಳಿದ್ರೆ ನಾವು ಹೇಳ್ತೀವಿ. ಅಲ್ಲಲ್ಲ, ನಿಮ್ಗೆ ಕೇಳಲೇ ಇಲ್ಲ, ನಾವು ಹೇಳಿರೋದಲ್ಲ. ನಮಗೆ ಕೇಸ್ ಹೊಸ ಫೈಲ್ ಮಾಡಿರೋದು ಗೊತ್ತಿಲ್ಲ. ನೀವು ಹೇಳಿದ್ರೆ ನಾವು ಹೇಳ್ತೀವಿ, ಈ ಗ್ರೂಪ್ ಬಂದಿರ್ತದೆ. ಹೌದಾ? ಈ ಗ್ರೂಪಿಗೆ ಬರ್ತದೆ, ನಿನ್ನೆ ಫೈಲ್ ಮಾಡಿ ಮಾತಾಡಬೇಕಾದ್ರೆ ಸರ್ ಅವ್ರಿಗೆ ಸೈನ್ ಮಾಡಿ ಕೊಡ್ತೀವಿ ಸರ್. ಬನ್ನಿ ಸರ್, ಊಟ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ, ಮಾಡ್ಕೊಡ್ತೀನಿ. ವೇಟ್ ಮಾಡಿ.
ನಾಳೆ ಮೂವ್ ಮಾಡ್ಲಾ ಸರ್? ನಾಳೆ ಮೂವ್ ಮಾಡ್ಲಾ? ಅಲ್ಲೇ ಸೈಡ್ ಅಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೆ ಪದೇ ಪದೇ ಬರೋಕ್ಕಾಗುತ್ತಾ?
Repeat. ಇದಾ? ಹಾ. ಇದೆ.
Sir, 33 is SOB ಬೇಕಾ? 33 ಅಲ್ಲಿ SOB ಬೇಕಾ ನಿಮ್ಮ ಮ್ಯಾಟರ್ ಬೇಕಾ? Not required. ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಅದು ಹೇಳಿದ್ದೆ. ಇದು ಕಾಪಿ ರಿಸೀವ್ ಆಗಿದೆ. ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿ.
Password ಹೋಗ್ತಿಲ್ಲ, please continue.
Continue. ಅಲ್ಲೇ ಇರ್ಬೇಕಲ್ಲ ವೈಟ್ ಕಲರ್ ಇಲ್ಲಿ ಇಲ್ಲಿ ಹಿಂದೆ ಇಟ್ಟಿದ್ದ ಅದ್ರ ಕಲರ್ ಅದು ವೈಟ್ ಕಲರ್ ಅನ್ಸುತ್ತೆ ಅದಲ್ಲ ಅದಿರ್ಬೇಕು ಅದಿಲ್ಲ ಅಂದ್ರೆ ತಗೊಂಡೋಗಿರ್ಬೇಕು. ನಾಳೆ ಮೂವ್ ಮಾಡ್ತೀನಿ ಅಂತ ಇದೆ. ಆಯ್ತು ಮೂವ್ ಮಾಡಿ.
With my lord's permission, lords, in the EP 10 of 2023, arguments that got concluded in the previous week in Dharwad, my lord. My lordships had permitted us to file written submissions, my lord, but that is not forthcoming in the order sheet. Therefore, registry is refusing to accept it.
Not written submissions.
Written synopsis, yes.
Synopsis. Kodi.
Just written synopsis.
My lords,
Yes.
morning I moved the memo, but they are not accepting. It is a pending matter. IA has been pending, my lords. Kindly have this matter day after tomorrow.
No written arguments. You please correct it and type it as synopsis and give it.
My lord, inside it is mentioned as synopsis. Inside it is mentioned as synopsis. Inside it is mentioned as synopsis. On the top it's, I will correct it.
It's been, IA has been pending, my lord. Kindly have this matter day after tomorrow or tomorrow, my lord. I have moved the memo in the morning session, but the court officer is not accepting the memo. Since it's been in B group, but IA has been pending, my lord. IA has been pending.
IA for what?
IA for vacating stays there.
Vacating barodilla. Yes.
Continuation, serial number 32. Sidmalappa PM. The lords of this is
Affair for petitioner, lordship. In this case, lordship, I filed the impleading application. The impleading applicant is the legal heir of deceased Ganga Lakshmamma. Hence, LR's application, filing LR's application is not arise, please, lordship. The notice was served on the impleading applicants. The impleading application may be allowed, and I may be permitted to implead them as a respondent number.
ಅವ್ರನ್ನೇ ರೆಕಾರ್ಡ್ಸ್ ತರಕ್ಕೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ. ಯಾರು ಹಾಕಿದ್ದಾರೆ?
ನಾನೇ ಹಾಕಿದ್ದೇನೆ ಸರ್. I have filed.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಸರ್.
ಅಲ್ಲ, what will happen, Lordship, first instance filing the writ petition, your Lordship, I am not made a party respondent 5 and 6, please, 4 and 5, please, Lord. The direction of this honorable court, I made a party, but at the time of making the party, your Lordship, Ganga Lakshmamma already dead. It is referred in my writ petition. She is already dead. Enough that I am not able to file a LR's application. Instead of filing a LR's application, I filed the impleading application, Lordship.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾದ್ರ ಮೇಲೆ
ಹೋಗಿ ಸರ್ವಾಗಿ ಬಂದಿದೆ. They have appeared through counsel, please, Lordship.
ಯಾರು?
The impleading application.
ಗಂಗಾಧರಪ್ಪ. ಎ.ವಿ. ಗಂಗಾಧರಪ್ಪ.
The impleading application is allowed, matter may be considered on merit. They have filed the original suit before the senior civil judge Nelmangla court, please, Lordship.
ಅವ್ರು ಬರೀ 6 and 7 ಅಂತ ಹಾಕಿದಾರಲ್ರಿ.
5 already impleaded, your Lordship. 5 already impleaded before this court.
Mr. A.V. Gangadharappa for R5 and also for impleading applicants R6 and R7. In the cause list, it is reflected.
5 go average.
What about 4?
4 is no more, Lordship.
ಅವ್ರಿಗೆ
The impleading applicant number 5, 6 and 7 are the legal heirs of 4, please.
Order on IA number 1 of 2024. This application is filed by the petitioner to implead the proposed respondents. Full stop. Learned Counsel Sri A.V. Gangadharappa has already entered appearance
Please,
for the proposed respondents. Full stop. Learned Counsel for the petitioner submits that respondent number 4, Srimati Ganga Lakshmamma, was impleaded subsequent to the writ petition being filed and in terms of the directions issued by this court.
please, sir.
Full stop. However, it was found that Srimati Ganga Lakshmamma had passed away long ago,
Please, Lordship.
and therefore this application has been filed. Full stop. Next para. The application is allowed. The proposed respondents number 6 and 7 are permitted to be brought on record. Full stop. Respondent number 5 is already on record.
Please, Lordship.
Full stop. Learned Counsel shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today.
Seal number 33, Victor Manoharan, yes, non-filing of statement of objection.
Third,
Let's have served copy, Miller's son.
you received copy.
No, I've filed it
They
in
have
the
served in the
registry.
registry, my lord.
Huh?
They are filed in the registry, my lord. I will verify.
Registry na.
ಅದೇ ನಮ್ದು
No, I served
ಹೈಕೋರ್ಟ್
in
ಗವರ್ಮೆಂಟ್
the-
ಅಡ್ವೊಕೇಟ್ಸ್ ಕಾಂಟ್ರಾಲ್ ಫೈಲ್ ಮಾಡಿ ಅಕಮೆಂಟ್ ತಂದಿದ್ದಾರೆ ಇವತ್ತು.
You served in the office of the Advocate General.
Yes, my lord.
General office and I filed it in the county.
Learned Counsel for the petitioner submits that he has furnished copy of the writ petition along with annexures in the
Then what happens is, my lord, I say learned arbitrator should hold the proceedings in Bombay. They say it should be on VC. Learned arbitrator dismissed it. They came before your lordships, re-agitated it. Your lordships dismissed it.
Yes.
Go to the Supreme Court, dismissed.
Yes.
All I'm saying is now that learned arbitrator says he's recusing. Please appoint any other learned arbitrator. Now, if all I say is this, insofar as Bombay, let them go and agitate before the Bombay High Court later. Why should our court be second?
No, where is that?
My lord, recusal order, your lordship should please see at page 122. I'm sorry, it's not an order, it's an email, it's a communication. He expresses some, my lord, personal reasons and says that I'm unable to continue, and also that he is unable to travel to Bangalore, etc. Therefore, he says, let you appoint anybody else and thread that. He says, recording of evidence and final hearing, I would not be able to travel to Bangalore on account of my personal situation. Last but one paragraph. Therefore, he says, I want to recuse Antare. Therefore, I approach your lordships. Your lordship's original appointment order is June 2024. Instead of fighting over VC, Bombay, Delhi, etc., had they come by now, they would have completed the arbitration. They want to just keep the fire hanging. That is why, my lord, I have moved the application, though they really should have done it. That's all I had to point out to your lordship. What remain, my lord, I will suggest 3-4 unimpeachable names. Your lordship, my lord, decide. Let them decide. I have no. Justice Bopanna may be appointed. Justice Gunjal, Justice Chandrasekhar, anybody, my lord, can be appointed. I have no difficulty. All I'm seeking is substitution. Any other plea can be raised before the learned arbitrator. No difficulty about it. And if Bombay court they want to say, let them say it in Bombay. What is the problem? I'm not coming in the way of any of that. I am not appearing in Bombay. Possibly the same learned counsel may not are appearing there also. I'm not commenting about that also. I have got nothing to do with that. That's a different entity. There's a different entity. They say it's interconnected. No difficulty. Let them point it out in Bombay. Understand?
My lords, if I may submit.
Your lordship's original order was at page 18. Operative portions at page 32.
Anyway, this was already on cards because he had expressed that time itself that he will not be able.
He had expressed. That's why, my lord, I have moved the application. That's all. There's nothing.
Yes.
My lords, if I may submit, it's not so straightforward, my lords. What had happened was the Bombay High Court had already appointed an arbitrator. The claimant's contention always was that they're connected arbitrations. We had not asked for a consolidated arbitration. We had said that the same arbitrator may be appointed in both. In fact, this very honorable court has come to a conclusion that they are related. Same arbitrator, it makes sense in the interest of justice to appoint the same arbitrator. Therefore, the same arbitrator came to be appointed.
If that arbitrator is saying,
Indeed, my
I'm
lord.
sorry, I will not be able to come.
I understand. All I'm just trying to say is, my lords, the way the picture is painted is not entirely correct. Pleadings have been completed. It is not that the arbitration.
What do you want?
My only request is, my lords, the reason the arbitrator had recused was because of his health reasons and inability to travel.
Yes.
This court has already come to a conclusion that the matters are related and a common arbitrator would serve the interests of justice. Therefore, in fact, my request is that parties may be given an opportunity to explore an arbitrator who's in a position to conduct both Bombay and Bangalore proceedings. In fact, what the Supreme Court has said with respect to Section 15 of the Arbitration Act, under which the substitution is filed, is that once there's a substitution request, the same manner in which the appointment had happened previously should be considered again. Therefore, what the Supreme Court says is that if the parties were to agree and come and appoint an arbitrator, that same process may be followed again. Therefore, my only request was that about a week or two may be given to suggest some names so that we can find out that this same thing does not repeat. That is all I'm saying. It is not a question of who's to appoint first, whether Bombay, whether Karnataka. There is no such battle between the courts that as is being portrayed. Bombay had appointed first, Karnataka chose to appoint the same arbitrator. And in fact, the reason why the orders came to be dismissed, my lords, is not on any merit, except for the fact that this honorable court held and even the Supreme Court held that if the parties are not consenting, we had said that given the interconnectedness of the arbitration, the arbitrator may travel to Bangalore and hold it. He expressed his inability to do so because he said he has some health issues. Therefore, we suggested it may be done by VC, to which the respondent objected. We then sought for a clarification by the arbitrator and by this honorable court to say that the court may say that it can be conducted through VC. At which point the court said that without consent we cannot. It is not a question of merit. It's not a point on interconnectedness of the matters. Therefore, a humble request is that finding still stands and the same arbitrator ought to be appointed for both proceedings. And in accordance with what the Supreme Court has held in section 15, parties may at least attempt to find an arbitrator who's in a position to travel, who can conduct proceedings in both arbitration, and then we may come back. Otherwise, the same process may repeat where again parties will say that it may be, or it may be clarified that VC can be done so that it can continue. I'm not.
This is,
therefore,
your
my
lordships now sees the cat is out of the bag.
I can place the Supreme Court judgment on record. The Supreme Court has clearly held that the same process that was followed for section 11 has to be followed for section 15.
That is why the first order was in your favor.
Please, my lord.
Please understand.
Therefore, my request.
Now, what to do if the arbitrator
1 year,
is
my
saying
lord,
that-
this is what they've done. I'll tell your lordship,
Not
they
1
go
year,
on
my
and on
lord. I
saying
am
the
the
same thing.
claimant. I do not know why they're saying 1 year. Pleadings are complete. Pleadings have been filed. The arbitrator, in fact, recused in Bangalore, then subsequently recused in Bombay. All pleadings were filed. They had filed a section 16 that came to be dismissed. So it is not that arbitration was not proceeding. Arbitration was proceeding by itself on the side. These issues were being heard alongside. It is not that anything was delayed. All I'm requesting is that the same may not repeat. Therefore, I'm saying that parties may be given an opportunity to check if some of these arbitrators, it is not that I have any opposition to some of the names on the panel, etc. We may be allowed an opportunity to ascertain if in fact the same arbitrator can conduct both hearings, because that has been a stated endeavor from the beginning. And this court has also recognized that issue. Therefore, all I'm requesting is after a week, we may be at least permitted to ascertain if there is a possibility of the same arbitrator conducting both. In fact, it's their objection to it. Why have they filed this IA to move it along? Because they have an objection. They want to go behind this order.
Arbitrator means it's the same arbitrator who we had
No,
appointed.
the same. Now Bombay also he has recused, my lord. So Bombay also has to appoint as arbitrator. Therefore, we only want to ascertain a few names and place before this court of such learned arbitrators who are in a position to conduct hearings both in Bombay and Bangalore as required, because they have objected to VC hearings.
No, but he has said.
He has said he is recusing both, my lord.
No,
He has
no,
recused
no.
both.
No, he has said. Huh?
It's not on record. They have not placed it on
I
record.
continue as
not
arbitrator
No, he's
appearing in
not
Bombay.
placed it. He's not placed it on record. I have the.
in other dispute between the claimant and respondent.
He has recused, my lords. I can place that on record.
Which is being held in Mumbai.
I am
can
not
place it
appearing
on
in that
record. He's
case. I
recused
don't
there.
know.
It's not on record. He has recused there as well.
I do
I
not
have the
know.
communication with me. I can show it to my lords or I can place it on record. Therefore, I'm saying even though he may not be on record, but I'm pretty sure that he's aware that he has recused in Bombay and that arbitration has stopped. Therefore, my humble request is that a week's time be
I'm sorry, I
granted.
take some umbrage to that sort of a statement. He must be aware, Andre. This is a
He is
very
unaware,
unfair.
it's the same. If his client has not instructed,
on,
that's not on me, my lords. Nevertheless, I am stating
a bit
before this
too much.
honorable court that he has in fact recused on 19th June 2025 because his health, he says, because of his health reasons, he's not in a position to continue. Therefore, both arbitrations now need substitution. Therefore, my only request was that a week's time may be granted. I will ascertain if there are any learned arbitrators who are in a position to conduct both, because that right of mine has been recognized by this very honorable court that in fact they're similar, that the ends of justice will be served. They're saying they're different arbitrations. One is, and my lords are aware of the company, Price Waterhouse. One is an LLP, one is a company. It is corporate restructuring and nothing more. That's my stand. It remains to be proved. Therefore, all I'm saying is a week's time may be granted. Let me ascertain if there are any names I can suggest which may be acceptable to this honorable court for arbitrators who are in a position to conduct both. Then I can also go and submit the same before the Bombay High Court, and the same arbitrator can be appointed for both proceedings. That is all I'm requesting, my lords. Nothing more.
Can I now point out something, my
But
lord?
they have objection to that as well.
Yeah, I'll tell the court why. I'll tell the court why I have something to say. Please see the email of 122, page 122. October last year, he writes, today my learned friend would tell your lordship, so give me a week, I will ascertain. 6-8 months has passed. They have done nothing. Then, my lord, please record that the claim is abandoned. I have no difficulty with it. I have a sword hanging on my head. Why should I, my lord, let it hang on my head? I'm answerable, my lord, to the client. If they want somebody, let them, my lord, find out. No difficulty. What were the 8 months they wait, 9 months they wait, and then now tell your lordship they want 1 more week. Possibly now that learned arbitrator has, now that, my lord, she says that he's recused in Bombay, they want to move the Bombay High Court, take an order there and come and tell your lordship the fait accompli. This is what perhaps
Sir, this
is
is just
passing, my lord, is what I can say. No, I'm
conjecture
sorry, I didn't
about what
interrupt
is,
you.
if he's not even aware of the Bombay High Court
I said
proceedings, I don't know
possibly,
how-
please hear what I'm saying, madam.
Yes.
This is not the way.
That's why I said it's
Therefore, my lord,
conjecture.
what I'm submitting is if they have waited from October, there is no reason to wait some more time for
Lords,
them.
I'm only requesting a week. I'll ascertain some names. That's all I'm requesting.
Yes. IA number 2 of 2025.
Great.
It's filed. By the respondents, Allah.
Also,
Huh?
respondents
By the
to the
respondents.
CLT. Houdu.
Seeking to substitute and appoint a retired judge of this court from the panel of arbitrators maintained by the Arbitration and Conciliation Center, Bengaluru, in view of the fact that the sole arbitrator earlier appointed by this court has made a communication dated 9th of June.
18th October 24, it appears.
What is 9 June?
18th of October
18th.
2024.
Please.
Subsequently, there were all the proceedings on clarification. The final email is 9th.
Expressing his difficulty to hold arbitration at Bengaluru, on health grounds. Full stop. The sole arbitrator has therefore withdrawn from the arbitration. Full stop. Next para. Learned counsel for the petitioner, however, seeks for a week's accommodation to secure instructions and make submissions. Full stop. Release this matter on 5th of August 2020.
Great.
Serial number 39. P. Srinivas.
We have a petitioner in 39.1, my lords. Lords, yesterday I filed an application for detacking this petition. My lords. And there is a request from the advocate. Due to medical emergency, he has been outside. Then call Madi Srinivas. May I kindly have it on next week, my lords. The IA will be put up.
IA for?
IA for detagging, delink madlike yesterday I filed it. Because the prayer sort is different in this.
Why was it connected then?
Based on their request, it was connected. And when we perused the writ petition, that prayers were different. And therefore, we had filed an application for detagging. I have served the copy upon them.
39.1 kudi.
39.1 KLR. In their writ petitions, DC directed to initiate criminal proceedings against the revenue authorities, my lord. That direction have been challenged. In my writ petition, the suo motu proceedings by the AC to set aside the body has been challenged, my lords. My senior will address, my lord. May kindly have it on next week.
ಅವರು ಇಲ್ವಾ ಪ್ರಕಾಶ್ ಟಿ ಹೆಬ್ಬಾರ್ ಅವರು?
I appear for them.
Not Mr. V. Srinivas.
No, my lords. Medical emergency ಇದೆ ಅಂತ ಅವರು
ಯಾರು?
B. Srinivas. He just informed me, lords.
ಯಾವಾಗ ಬೇಕು?
Next week, my lords. Any day on next week.
At the request of learned counsel. For the petitioner in WP number 55053 of 2016, released this matter on 5th of August. These matters.
Serial number 40, K. Narasimhan. This matter may be taken up next week, my lord, any date.
ಯಾವುದು?
May be taken up next week.
Education. ಯಾವುದು?
Education.
40.
Please. May be taken up next week, my lord. There's some inconvenience.
ಏನ್ರಿ 2021 matter? At the request of learned counsel for petitioner, released this matter on 5th of August.
Please, my lord, interim order may be extended.
Interim order granted earlier stands extended till the next date of the.
Great.
41, Tejasvi KV.
For petition. Lord, this is I'll just submit the sequence of events, my lord. This matter has already been disposed of, my lord. The sequence of events are like this. My lord, I filed a complaint before the RERA for the refund of money from the builder. The complaint was allowed. Then the recovery certificate was issued, my lord, by the RERA in favor of the deputy commissioner, my lord. This is the respondent number 1. The respondent number 1 has not taken any action to implement the recovery certificate, my lord. I have filed 2 representations. Those representation has not been acted upon, my lord. Then I filed this petition before this honorable court, directing the respondent number 2 to implement the recovery certificate, my lord. But while passing the order, there are certain mistakes are erupted in the order, my lord. That's why I filed an application for the rectification of the order. My lord, the first mistake. In the paragraph number 2, my lord, the real estate estate regulatory authority has passed the impugned order at Annexure B without notice to the petitioners. That is not the grievance at all, my lord. The RERA has passed an orders after giving an opportunity of both the parties, my lord. But wrongly it has been written, it has without giving an opportunity, without notice to the petitioners, my lord. That is the first one. Now, my only grievance before this honorable court in my writ petition is that direct the respondent number 2 to implement the recovery certificate, my lord.
Order copy. Order copy.
It has directed the petitioners to pay rupees 41,52,000.
That was the order by the RERA, my lord.
That is correct.
That's correct, my lord. But thereafter, my lord.
Direction is against you.
No.
Direction is against you to pay the amount.
No, not. I am the complainant before the RERA, my lord.
This statement is wrong.
Yes, my lord.
The authority has directed respond number 3 to pay, na?
The RERA has directed the builder, that is the respond number 4, my lord.
Respond number 3.
Builder.
ಇಲ್ಲ 4 ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ, ಹೌದು, respond number 3, my lord.
So instead of petitioner, it should have come as respond number 3.
Yes, my lord.
To pay rupees so and so. ಆಯ್ತು.
Now the relief that I have sought in this repetition, my lord, is that direct the respond number 2 to execute the recovery certificate issued by the RERA. But the order is something different, my lord.
See, we were passing two sets of orders.
Yes, my lord. One was the DRT.
One, we used to direct the Tahsildar or the Deputy Commissioner to proceed and conclude the proceedings. ಇದು ಅದು ಬಿಟ್ಟು ಯಾವ್ದು ಬೇರೆ ಬಂದ್ಬಿಟ್ಟಿದೆ.
This is the two sets. One was for the builder. DRT quorum ಇಲ್ಲ ಅಂತ
ಹೌದು.
ಅದಕ್ಕೆ.
My lord, now the problem is that, my lord, the banks are behind me. ಯಾಕೆಂದ್ರೆ ನಾನು ಬ್ಯಾಂಕಿಂದ ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Anyway, that cannot be done without hearing the third respondent.
My lord, I am not.
I'll recall this order. Yes. You can go before the row.
My lord, my only submission, my lord, I am not.
The direction cannot be given without hearing the respondent.
My lord, I understand, my lord. I understand, my lord.
Notice ಹೋಗಬೇಕಾಗುತ್ತೆ.
My lord, I am not pressing any relief against the respond number 3, my lord.
ಹಂಗ ಆಗೋದಿಲ್ಲ.
My lord, I am pressing only the relief only against the respond number 2, my lord. There is no grievance against the respondent number 3 in this repetition, my lord.
In fact, it is not a rectification. You should have asked for a review. ಆಗೋದಿಲ್ಲ ಇದು. ಬರ್ಕೊಳ್ಳಿ. This writ petition was disposed of by order dated 21st of February 2025. Full stop. But learned counsel for the petitioner has filed IA number 1 of 2025 seeking certain corrections in the order. Full stop. However, after hearing the learned counsel for petitioner, it is now clear that the relief sought for by the petitioner is to direct
Respondent number 2.
I have to spend a lot of substantial time again before the concern.
The Deputy Commissioner, respondent number 2, to execute and implement the orders passed by the first respondent, RERA, for recovery of a sum of rupees 40,03,836 from respondent number 3. Full stop. However, the writ petition was disposed of on a wrong premise that the petitioner was aggrieved by the order passed by the first respondent authority. Full stop. Next para. Nevertheless, having regard to the prayer made by the petitioner, such a direction cannot be issued by this court without issuing notice to respondent number 3. Full stop. Therefore, the order dated 21st of February 2025 stands recalled. Full stop. The writ petition is restored to its original file. Full stop. Office is directed to list this matter before the bench having roster.
Great. 42. Puneet C.
For the petitioner, respondent number 11 is died, please, my lord. I'll take steps. Respondent number 11, dead, please, my lord. I have taken notice. It has returned as he is dead, and I have to take notice. I'll take steps within 2 weeks, please, my lord.
2 weeks are granted at the request of learned counsel for petitioner to take steps
Deceased R11, please.
in respect of deceased respondent number 11.
Please, my lord. Interim order may kindly extend.
Interim order granted earlier stands extended to the next date of hearing.
Much obliged.
Seal number 43.
Before the, let's have filed an IA number 3 of 2025 is filed by me. I'm the complainant before the authority. I have filed, but the name is not being reflected. I'm the complainant. I was at the behest of my complaint only. Inquiry was initiated, and there's also I was also, in fact, I was present at the time of inquiry. Also, there's a finding also by that I was present. And there is a finding.
Again, complaint.
They had complained that Sarkari jaga otturi ಮಾಡ್ಕೊಂಡು ಕೃಷಿ ಹೊಂಡ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ I had given a complaint. On the basis of the complaint which I had given, they had initiated inquiry, ಬಂದು ಮಹಾಜರೆಲ್ಲ ಮಾಡಿ, there was a finding that there is a government land which otturi ಆಗಿದೆ ಅಂತ ಹೇಳಿ. There was a letter, Lokayukta was also, I had also initiated proceedings, and FIR has been filed, and the charge sheet has also been filed under section 192A of the Land Revenue Act.
My lord, the stage was with respect to IA number. He has filed IA number 3 of 25, my lord, sir. We need seeking for 2 weeks time for filing objections on the same. He is an impleading applicant, my lord. He has not yet been impleaded yet. Proposed impleadment.
I have also produced a few documents along with the IA seeking.
My lord, it has not been impleaded yet, my lord.
Yes, what have you stated in your application?
I have produced a few documents along with Tanika Varadi's Annexure C before the writ in the memorandum of writ petition, my lords. The complaint which I have filed is document number 2. It is on the basis of this complaint only that proceedings were initiated. Page number 16 of my I have written ಮಾನ್ಯರೇ ವಿಷಯ ಸರ್ಕಾರಿ ಗೋಮಾಳ ಜಮೀನು ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಕರಕಟ್ಟೆಯನ್ನು ಅಕ್ರಮವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿ ಸ್ವಂತಕ್ಕೆ ಬಳಕೆ ಮಾಡುತ್ತಿರುವ BM ನಂಜೇಗೌಡ, that is the petitioner before this honorable court, ಎಂಬುವರಿಗೆ ಅನುಕೂಲ ಮಾಡುವ ದುರುದ್ದೇಶದಿಂದ ಸ್ವಜನ ಪಕ್ಷಪಾತ ಭ್ರಷ್ಟಾಚಾರದ ಮೂಲಕ ಪ್ರಜ್ಞಾಪೂರ್ವಕವಾಗಿ ಅಧಿಕಾರ ದುರ್ಬಳಕೆ ಮಾಡಿ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿ ದ ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್ 1964 ಕಾಯ್ದೆ ಮತ್ತು ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಸೊ ಕಾಯ್ದೆ ನಿಯಮಗಳನ್ನು ಸ್ಪಷ್ಟವಾಗಿ ಉಲ್ಲಂಘಿಸಿ ಗಂಭೀರ ಅಪರಾಧವೆಸಗಿದೆ ಡಾಕ್ಟರ್ ಕುಮಾರ್ IAS officer. He is making allegations as against this one here, but on the basis of this complaint only, my lords, inquiry was initiated. The document number 1 is the Tanika Varadi, which is there. The document number 1 and
in this case,
and at page number, if my lords may kindly see page number 14 of document number 1, my lords. I'll just take my lords to the operative portion of the document Tanika Varadi.
This Tanika Varadi is produced by them.
Yeah, they have impugned this Tanika Varadi.
Where is that?
Annexure C allide adu. Page 35, my lords.
Yes.
Page 40 is the operative portion. I mean, I will just read.
Ullekha 1.
My lord,
Number 35.
In fact, they made allegations in the memorandum of writ petition also that it's on the basis of my complaint only that.
Annexure C.
yes, my lord.
Ullekha 1.
Yes, my lord.
ಓದಿ.
ಪ್ರಭುಸ್ವಾಮಿ BN ಪುಟ್ಟಸ್ವಾಮಿ ಬೊಪ್ಪಸಂದ್ರ ಗ್ರಾಮದವರು ಮನವಿ ದಿನಾಂಕ 23/10/2024 ಮತ್ತು 3/1/25.
This person.
Yes, my lord. My lord, the thing is that the inquiry was conducted. The Tahsildar themselves, they have placed a record telling that there was no encroachment.
All he is saying is permit me to come on record because the entire proceedings were initiated at my behest.
My lord, kindly grant us 1 week
Is
time, my lord.
anything to be told, I will bring it to the notice of the court. It may consider. That
My
is
lord,
all.
1 week time may be granted, my lordship.
For what?
For filing objections. We haven't done, my lord, the reason.
I will record your objections.
My lord, otherwise kindly pass over the matter, my lordship. Senior will be here. My lord, kindly pass over the matter, my lordship. My lord, on sincere request, my lordship, kindly pass over the matter, my lordship.
Order on IA number 3 of 2025.
My lord, please, my lord.
Application is filed.
Sincere request, my lordship.
I will notice your objections.
But,
even if your senior comes and submits, it will be same thing.
No, my lord, we'll file our objections, my lordship. At least.
We'll notice your objection.
A week's time may be granted, my lord.
No, not necessary.
A week, my lord. A week's time may be granted. We will file our objections, my lordship. The reason behind this is not the first time he's coming in, my lordship. There's another. He's been harassing like this for quite some time.
I pointed you to Annexure C, which is the inspection report or a report submitted by the authority saying that the proceedings were initiated at his behest. Is it not enough?
My lord, I will not be able to take the decision.
In all fairness, you should have implemented him.
Kindly.
You didn't do it.
Kindly pass over the matter, my lordship. ಈಗಲೇ ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
No.
My lord, actually, my lord, pass over ಮಾಡಿ ಸ್ವಾಮಿ. Senior ಬರ್ತಾರೆ ಸ್ವಾಮಿ.
ಬರ್ಲಿ ಆಮೇಲೆ.
ದಯವಿಟ್ಟು ಸ್ವಾಮಿ.
Let him come.
Pass over ಮಾಡಿ ಸ್ವಾಮಿ. 5 minutes ಅಲ್ಲಿ ಕರೆಸ್ತೀನಿ ಸ್ವಾಮಿ. Thank you, my lord.
Pass over. Yes.
44, Vaishali Hegde.
For the petitioner in this case, my lord.
Matter, my lord, I seek for short accommodation for this reason, my lord. The annexure A is issued by the respondent Tahsildar Mandya, my lord. He was not a party to the proceedings at the earlier stage, my lord. Subsequently, my lord, from the order sheet, my lord, it is noticed that on 24/6/2025, the Tahsildar Mandya has been impleted, my lord. Thereafter, my lord, this court directed to file statement of objections, my lord. Of this, my lord, I seek for short accommodation, my lord, to secure records and to file statement of objections. On 24/6/2025, my lord, he is impleted.
Learned AGA submits that by order dated 24/6/2025, the Tahsildar, Mandya Taluk was directed to be impleted and is accordingly impleted. Full stop. The learned AGA therefore submits that a short accommodation may be given to enable the respondents to file statement of objections. A week's time is granted to the respondents. 2 weeks are granted at the asking of the learned AGA to file objections to the petition. Yes, please.
45.
I appeal for the petitioner. This petition is seeking for change of kata and pani malats in favor of the petitioner pursuant to the sale deed executed by the court commissioner malats. Tahsildar has issued an endorsement stating that there is no permission to sale obtained before getting the sale deed.
Yaudu? Annexure A na?
Annexure A is the endorsement that is given, malats. A typed copy is at page number 12. Page number 13 alli shara ide. ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಪೈಕಿ ನಂಬರ್ ಆಗಿದ್ದು ಲವೆನ್ನಿ ಮೋಜಣೆ ನಕ್ಷೆ ಇರುವುದಿಲ್ಲ. ವಿಕ್ರಯದಾರರು ಮಾರಾಟ ಪೂರ್ವ ಸರ್ಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಪಡೆದಿರುವುದಿಲ್ಲ ಹಾಗೂ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮಗಳ ಉಲ್ಲಂಘನೆ ಆಗಿರುವುದರ ಬಾಬ್ತು ಯಥಾಸ್ಥಿತಿ ಉಳಿಸಲು ಕೋರಿದೆ.
You know what is the background? I didn't understand.
Malats 1974 malats, one Junjaya sold the property to Ugrappa malats. From Ugrappa.
Please come to the synopsis.
Please. 16/10/1974, Junjaya sold the property to Ugrappa, my lords. 14/12/1978, Ugrappa in turn sold the property to Joganna. 17/1/2000, Joganna died, my lords. Mutations were changed in name of Joganna. 17/1/2015, family members of Joganna entered into an agreement of sale in respect with the petitioner. He has not executed the sale deed. I have filed OS for specific performance. There, 7/7/2017, I filed OS, my lords. 9/9/2017, the suit is decreed in terms of the compromise petition. Then, my lords, they did not come up to execute the sale deed. I have filed execution petition on 4/9/2018. 4/9/2018, court commissioner was appointed and a sale deed was executed through court commissioner in favor of the petition, that is Annexure F, my lords. Pursuant to this sale deed, my lords, have given representation on 29/1/2019 to change the kata in my favor. Tahsildar issues an endorsement on 4/5/2019 as per Annexure A. That I have not taken, no permission to sale was obtained. Permission to sale was obtained anta baritar.
Yen permission re?
It seems my lord, it is a government land that was suppressed.
Yena?
It seems my lord, it is a government land.
Government land.
That was suppressed, my lord.
I have produced.
It was granted in favor of the vendors of the petitioner.
Already.
There was a condition, my lord.
No. Where are the RTCs?
My lords, my vendor's mutation is at Annexure E, my lords.
Present petition, my lord, the suit decree is not produced. No documents are produced, my lord. Therefore, my lord.
Allah, that is why I am asking for old RTCs.
27, my lords, mutation is changed in the vendor's page number 27, typed copy. 13/78/79, my lords. I produced the sale deeds of my vendors also.
Sale deeds allama, revenue records I am asking for.
Mutation is at page number 20.
Where are the old revenue records?
That I'll have to secure. That I'll secure. This is a sale deed executed by the court commissioner.
Sale deed, madam. Where are the old RTCs?
Old RTCs I'll secure.
To show that the RTCs were recorded in their names, earlier owners.
That I don't have, my lords, I'll secure it.
Then, learned counsel for the petitioner is required to place on record the RTCs or mutation orders showing entry of the names of the previous owners as khatedars of the lands in question.
And also the title deeds. And also the title deeds.
What?
Endorsement.
Registered documents of, and this is a document executed by at the hands of the court.
But this endorsement says, my lord, condition violation agide anta. Andre grant land eno adu gottagide. Adin grant land eno anta gottagide.
He has to be more clear and specific in his order. When will you get it?
Next Monday. Monday, by Monday.
Next, release this matter on 5th of August.
Please.
Yes.
46, T.N. Vishwanath.
Yes.
This case, my lord, without issuing notice to the petitioner, Annexure G, the order impugned official memorandum has been issued by the deputy commissioner. That is question before this honorable court, my lord. The few facts of the Karnataka number 57/1 belongs to the family of the petitioners, and it was in the name of Narayana, the father of the petitioner. And thereafterwards, subsequent to the death of Narayana, the Kaneshmari was effected in the name of this petitioner's mother, Jayamma.
Kaneshmari antandre, you are referring to municipal records.
That's what, Panchayat record.
Panchayat records.
Panchayat records. Panchayat records.
Then this is a property falling under the jurisdiction of the Gram Panchayat.
Gram Panchayat, they are in possession. Entire survey number 114 has been developed. Now what they wanted is 3.5 guntas for establishment of primary health center, wherein I am residing there, and there is a cow shed. All those things are there, and I have filed a suit against the government and also Panchayat. Court has granted decree for permanent injunction. That is also placed before this honorable court.
Let us. Let us see.
Now, lots annexure A may kindly be seen. Annexure A is the Kaneshmari Kata affected by the Panchayat, that is Kumbalahalli Gram Panchayati. That is a annexure pay, typed copy is at annexure page number 20, please. It is in the name of Jayamma.
We have no title deeds?
No, it is on Panchayat from so many years they are residing. Adi Panchayati property, in fact, Bhajane mane ide. Yure kattiradu. All photos have placed. And they are not challenged that decree also. Tumba hale idu. Then
Let us see.
the annexure B, please, my lords, that is the partition affected among the family. In this partition, this property has fallen to the share of petitioner.
Annexure?
Annexure B, please. And it is not in dispute. My lord. So annexure B is the family partition and a panchayat property. In that, there are so many properties have been partitioned. In that, this property has fallen to the share of petitioner. Next, annexure C may kindly be seen. My lord. Annexure C. Annexure C, D and E may kindly be seen.
And it is not by way of registered partition deed.
A panchayat property. Then
Panchayat palpati.
annexure C, D and E. What they are claiming is survey number 114 is a Guntopu. The entire area is developed. In fact, all so many hundreds of houses have come up. And it is in the panchayat limits and panchayat has assessed. And thereafter, when they tried to interfere in the year 2009, then I filed a suit for permanent injunction against state of Karnataka and also secretary of Kumballi Panchayat. That suit was decreed on, that is on 23rd of July 2014. And the suit properties are one and the same what I have mentioned in this. Now, the next document, annexure G may kindly be seen. I have placed everything, panchayat property, mutation extract, form number 93, taxpayer receipts, license and all those things. And this order has not been challenged.
Schedule mentioned in the suit.
And schedule, that's what I'll come, sir. Schedule that is pertaining to survey number 114 and ಹೇಳ್ತಾರೆ. But actually totally different.
ಇದು 2 page decree, judgment. And it is not even said whether notice is issued to defendant number 1.
It is served.
Ellide?
No, page number, that is, my lords, the prefix, the pursuant to service of summons, defendant appeared through their counsel but failed to read para number 3. Para number 3 of the judgment.
If it is state government,
yes,
it will be by the pleader there.
No, that's what counsel. That's what that is the reference. Pleader has to file wakalat. They have filed wakalat. That is what pursuant to the service of para number 3. Para.
They have shown the name of the learned counsel for defendant number 2.
No,
P. Ramchandra.
No, page number.
Defendant number 2.
Page number 31.
What about defendant number 1?
Defendant number 1, my lord, that is what they have stated. What this defendants and that is what pursuant to the service of suit summons, defendants appeared through their counsel but failed to raise the suit. So that is the reason, my lord, if lordship wants it, I'll place that document also before the honorable court stating that order sheet itself, I'll place it.
Yes.
Now, pursuant to this, now annexure G has been issued.
Schedule.
Schedule may kindly be seen. What the schedule is 3.5 guntas, that is survey number schedule they have mentioned. That is incorrect. As in present
Item number?
Survey number wise they have mentioned.
Item number 1.
Item number, not that. Illi our annexure G our ಹೇಳ್ತಿರೋದು. Page number 42.
42.
Page number 42.
ಅಲ್ಲ ಇಲ್ಲಿ shoot schedule ಅಲ್ಲಿ.
Shoot schedule ಅಲ್ಲಿ that item number 3 small bit ಇದೆ ಅದರಲ್ಲಿ. ಒಂದು ಮನೆ cow shed ಒಂದು ಇದಿದೆ ಆ ರೀತಿ ಇದೆ. So that is what. So that is the.
No survey number.
No survey number. Kaneshmar number ಇದೆ. Entire survey number. That is.
Why did you implead respondent number 1?
Which one, madam?
The defendant number one, why did you implead?
Defendant number one is also state is interested. That is what, my lord, because
The state come and object for your.
state and panchayat.
What is this?
No,
You said you don't see anything in the suit. Why have you
no, I
implemented
have
defendant
stated,
number
my
one?
lord, I have stated in my suit, my lord.
There's a lot of difference. If the
Interference-
objection has come from the Gram Panchayat,
Now
depend-
at present, Tahsildar, my lord, Tahsildar at present.
what have you stated, sir, in your plaint?
I'll place it, my lord, place the plaint.
Nothing is there.
No, I'll place it, my lord, plaint
Yes.
copy, I'll place it. My lord.
Yes,
I'll place the plaint and your lordship may kindly,
yes.
a week's time may be accommodated, please. I'll place it. My lord.
And you don't have any title deed with you.
Pardon?
You don't have any title deed with
No,
you.
title deed, that is panchayat is really the records. That is the reason, my lord. Sir, so many years they are staying there. That is the reason, my lord. In fact, no opportunity has been given. That is the reason. I'll place the plaint copy itself, my lord, because what I have stated against the state and also.
You can't go back to that plain copy now. Whatever has happened has happened.
No, that's what your lordship asked me that. That's the reason, my lord.
But there is nothing in the order. There is nothing in the judgment
No, that order, that,
as to why you have implemented defendant number one.
no, it is for the judgment, my lords. They have referred the documents and court has granted a decree, my lord.
Sir, in your plaint, you have
But
to say
if the
why you
learned-
have implemented defendant number one.
with great respect, my learned judge
The
has not
secretary of
referred, my
the
lord.
revenue department.
ಅಲ್ಲ ಅವ್ರು ಮಾಡಿ that is what the my lord now
ಅದ್ ಮಾಡಿ ಏನ್ ಅಲಿಗೇಷನ್ ಇದೆ ಅವ್ರ ಮೇಲೆ ಅಂತ
ಅವ್ರು ಬಂದು ಇಂಟರ್ಫಿಯರ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ that is the reason I have sought for permanent injunction.
ಯಾರು ಬಂದು ಇಂಟರ್ಫಿಯರ್ ಮಾಡಿದ್ರು?
State government represented by
State government will come and interfere.
No, Tahsildar and the
It will be
panchayat.
some officer of the state.
That's what represent.
Isn't
That's
it?
what Tahsildar is the person.
ಯಾರು ಮಾಡಿದಿರಾ ನೀವು? ಪಾರ್ಟಿ ಯಾರು
State
ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ರು sir.
ಅದೇ ಮತ್ತೆ
State represented by
by
revenue
its
department.
revenue secretary,
Revenue department.
as if revenue secretary came and interfered.
My lord, just I'll place that document, my lord.
Yes,
Weeks time we have accommodated so that I'll place that document and to substantiate that this decree has reached finality and they themselves admit that I am in possession. That is what, my lord, the Annexure G also says. And the entire area is developed. No opportunity to the petitioner. Because they should issue notice to the person who is in occupation. No, that is not done. They admit, but survey, they say no building, they have not come up with a specific plea that there is no building. There is building. Your lordship may kindly appoint court commission so that I am residing there. I have got power connection, everything I was residing there. So without notice to me, this Annexure G has been issued. At least they should issue notice and call upon this petitioner to place documents, my lord. Nothing has been done. Now their contention is it forms survey number 114. Because there are so many buildings have come up and panchayat is that Kumbhalli panchayat is as collecting the tax. At least they should hear me and then if they come up with a specific plea that yes, it is a property belongs to the government, then the things will be different, my lord. But here, no opportunity to the petitioner. I have not been heard, not even notified because I am in possession. That the documents also, photographs also are placed.
learned AGA is directed The government.
Government. In respect of which the forfeiture was incurred together with the amount of land revenue in respect to the holdings from the date of forfeiture. As may be forced by the Deputy Commissioner. During the period of not more than 21 months from the 7/2/2014, the Deputy Commissioner may, notwithstanding the expiry of the period specified in Rule 1, restore any forfeited occupancy or alienated holding which have been purchased on account of the government dues and which has not been disposed of otherwise to the person who has not been disposed of such occupancy or holding immediately before such commencement, on payment of the arrears in respect of which the forfeiture was incurred together with the amount of land revenue in respect of the holding from the date of forfeiture on the date of the restoration and expenses incurred so far in the recovery and further proceedings. Pada Bilu land forfeited to the government.
Yeah, where is that orders that I have passed? You don't know.
I have given. Otherly, my lord, there lordships have very clearly said there is arrears of land revenue due. That is arrears of land revenue due. This is arrears of
19639 of 2021, dated 5/9/2022. ಅದಲ್ ಮೇಲೆ ಇಟ್ಕೊಬೇಕಾಗಿರೋದು ಮೇನ್ ನೀವು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಮಾಡಿರೋದನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಕೋರ್ಟ್ ಆಫೀಸರ್. WP number 19639 of 2021, dated 5/9/2022. ಬರ್ಕಡ್ರಿ ಮೊದಲು 19639 of 2021, dated 5/9/2022. ಅತ್ತಕ್ಕೊಡ್ರಿ. Annexure
requested.
L,
Howd, government,
nothing has happened.
nothing has happened.
Berkeley. The petitioner is aggrieved of the impugned order at Annexure K dated 25/10/2019 passed by the Deputy Commissioner, Shivamogga, rejecting the application filed by the petitioner to restore the revenue entry in favor of the petitioner in respect of
Column 11.
survey numbers 29 measuring 4 acres, survey number 130 measuring 4 acres, and survey number 135 measuring 4 acres, total 12 acres, all situated at Ilre,
Lavagere village. Lavagere village. Sagar Taluk.
ಯಾವ village?
Lavagere village, Kasba Hobli, Sagar Taluk, Shumaga district.
ಅದು ಅವ್ರ ಅಡ್ರೆಸ್ ಆಯ್ತು.
ಅಲ್ಲ, land situation.
ಇದೆ.
ಅಲ್ಲ, ಅದು annexure K ಅಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ವಿಷಯ ಅಲ್ಲಿ ಇದೆ. ಸಾಗರ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಲವಿಗೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 130 135.
All situated at Lavigere village, Kasba Hobli, Sagra Taluk. Stop. It is also the grievance of the petitioner that the representation given to the Principal Secretary, Revenue Department at Annexure L has also not been looked into, and no orders have been passed in that regard. Full stop. Next paragraph. Undisputed facts are that the petitioner had availed loan from the Karnataka State Khadi Gramodyog Board in the year 1997-98 in a sum of rupees 1,07,500. And the non-payment of the loan along with interest transformed into orders being passed by the Tahsildar notifying the said lands belonging to the petitioner as Sarkari Pada. However, after the petitioner repaid the entire amount to the board, the petitioner approached the competent authority seeking to remove the encumbrance Sarkari Pada from the RTC. Stop. However, the Deputy Commissioner has passed the impugned order citing Rule 119(2) of the Karnataka Land Revenue Rules, 1966, and expressing his inability to accede to the request made by the petitioner, on the ground that the request was not made within the stipulated period of 3 years. Full stop. Learned counsel for the petitioner seeks to place reliance on a decision of a coordinate bench of this court in WP number 33222 of 2016, dated 27th of June 2022. Where it was held having regard to section 163 bracket 2 of the Karnataka Land Revenue Act, that the Tahsildar, before such occupancy or alienated holding is sold or otherwise disposed of, may cancel the declaration of forfeiture, if the defaulter or any person interested in the occupancy or alienated holdings pays the entire arrears of land revenue along with all expenses incurred to the recovery proceedings. Full stop. Next para. This court too in the case of Shivanna versus the Deputy Commissioner and others in WP number 19639 of 2021, dated 5th of September 2022, has held while considering Rule 119, that the intention of the amended provision which came into effect on 1/4/1988 is to grant relaxation and enable the revenue authorities to accept the application for cancellation of forfeiture even in cases where the land was sold and purchased on account of the government dues, but which were not disposed of otherwise. Full stop. For immediate reference, paragraph number 7 in the said judgment is culled out as follows. Anta hakondo extract ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. Next paragraph. In the present case, however, the forfeiture was not on account of non-payment of land revenue at the hands of the petitioner. Full stop. It was at the instance of the Karnataka State Khadi Gramodyog Board, where the petitioner had availed loans. Full stop. The Deputy Commissioner, in the impugned order, has noticed the fact that the petitioner has repaid all the loan amount along with interest to the board, and the board has issued no due certificate to the petitioner. Full stop. Despite the same, comma, the Deputy Commissioner has pleaded inability, comma, on the ground that the petitioner has filed the application after 3 years. Full stop. Next, as noticed in paragraph 7 of the decision of this court in the case of Shivanna, bracket Supra, comma, the intention of the amended provision which came into effect on 1/4/1988 is to grant relaxation and enable the revenue authorities to accept the application for cancellation of the forfeiture even in cases where land was sold and purchased on account of the government dues, comma, but which were not disposed of otherwise. Full stop. This is a clear case where admittedly the lands have not been disposed of at the hands of the revenue authorities. Full stop. It is not a case where the land revenues are due at the hands of the petitioner. Full stop. It is also necessary to notice that section 176 of the Act provides for circumstances where even the sale can be set aside. Full stop. Clause B of subsection 1 of section 176 enables the Deputy Commissioner to set aside the sale on the defaulting person depositing the amount before the Deputy Commissioner. Along with the costs of sale and a sum equal to 5% of the purchase money. Full stop. When such is the position of law, comma, when admittedly the lands of the petitioners have not been disposed of otherwise, comma, it was incumbent upon the Deputy Commissioner to accept the application filed by the petitioner while removing the forfeiture clause. Full stop. It is also necessary to notice that